Good morning, everybody. Happy Monday. Welcome to TCF Live. We will start our day in Allegan County, Michigan. This is Judge Joseph Scoselis.
In this case, he is charged. Just a reminder that we're on the record. We're recording everything and broadcasting live on YouTube. So any background noise will be recorded and broadcast as well. Make sure you're in a private place before you join our YouTube today. Again, the first case is file 260393FY, People versus Ethan Michael Estrie. In this case, he is charged through a felony complaint issued by the Allegan County Prosecutor's Office, a charge of resisting or obstructing a police officer, causing personal injury to the officer. Count 2 is a misdemeanor charge of possession of alcohol by a minor in a motor vehicle. Count 3, a charge of having additional open alcohol within the motor vehicle he was driving. On the second file, file 260397SM, he is charged in a second file with minor in possession of alcohol, second offense. Mr. Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Mr. Estrie for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He does qualify for a court-appointed attorney, and we would request that these matters be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
And on file 260397SM, are you also representing on that case?
Yes, Your Honor.
Okay, thank you. On the first file, again, that file is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set that for you within 2 weeks. Your probable cause conference is a week from Thursday, which is March 5th, and that will be at 1 p.m. in District Courtroom D. Preliminary examination itself is the following Wednesday, March 11th at 9 a.m. in this courtroom, District Courtroom A. Bail was set at warrant authorization at $1,000 cash or surety. Court file shows you posted a $1,000 surety bond. Bail will be continued in that amount with a condition you not possess or consume any alcohol, marijuana, or illegal controlled substances while the case is pending. Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will be with you at your next court appearance. And again, on that file, your next court appearance is a week from Thursday at 1 o'clock in the afternoon. On file 260397SM, the misdemeanor charge or enter not guilty plea. Set this for a jury trial. Again, indicate you're requesting an attorney at public expense. We'll set bail on this file at $500 personal recognizance with the same conditions as the first file. This case will be set first for a pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. On this file as well, the Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at your next court appearance. Next court appearance on that file, the misdemeanor file, will be sent to you by the clerk's office in the mail. So you are free to hang up from the court proceeding today. Again, your next court appearance is on the first file at 1 o'clock next Thursday afternoon. Okay?
Okay.
File 253502SM, People versus Austin Lee Frame, here this morning for arraignment charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office and a charge of larceny of $200 or more, but less than $1,000. Mr. Badger, please.
Sam Badger, appearing on behalf of Mr. Frame for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty, but does not qualify for a court-appointed attorney as his income exceeds the indigency requirements. And we would request that this matter be set for a pretrial and a trial, Your Honor. Thank you.
Letter of not guilty plea indicate your request for a public defender has been denied by the Public Defender's Office. So with that, Mr. Frame, you have two options, either to hire your own attorney with your own money, or to represent yourself in this case. Do you intend to hire an attorney or represent yourself?
Represent myself.
Would you like your trial set before a jury or before a judge?
A judge.
Will enter a not guilty plea, set this for a non-jury trial, indicate your request for an attorney at public expense has been denied by the public defender's office. Bail will set a warrant authorization at $300 personal recognizance. Bail will be continued in that amount at this time. Your case to be set first for a pre-trial conference with the prosecutor's office. If not resolved, it will be set for a non-jury trial in this courtroom, District Courtroom A. Court staff will mail to you the date and time of your next court appearance. So with that, you are free to hang up from the court proceeding this morning. Be looking for your next court appearance date in the mail, okay?
Thank you.
260381 SM, People versus James Matthew Heff, here this morning for arraignment charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office and a charge of malicious destruction of a building in the amount of $200 or more, but less than $1,000. Mr. Badger, please.
Sam Badger appearing on behalf of Mr. Heppy for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty, but does not qualify for a court-appointed attorney, as he will retain his attorney or an attorney for himself after the arraignment. And we would request that this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
For not guilty plea, set this for a jury trial, indicate the defendant is waiving his right to an attorney at public expense. Bail will set a warrant authorization at $300 personal recognizance and will be continued in that amount at this time. Case to be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. Court staff will mail to you the date and time of your next court appearance, which will be that pretrial conference. When you receive that, be sure to forward that on to your attorney. But with that, you are free to hang up the court proceeding this morning. Be expecting your next court appearance date in the mail, okay?
Okay.
About 260035 SM, People versus Kevin Brian Kinney, here this morning for arraignment charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office on a charge of domestic violence, second offense. Mr. Badger, please.
Sam Badger appearing on behalf of Mr. Kinney for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He has entered a plea of not guilty and does qualify for a court-appointed attorney, and we request that this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
Are not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. This is a protective bond. We'll continue bail in that amount with those same conditions until further order of the court. Your case will be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. Public Defender's Office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your pretrial conference. The date and time of the pretrial conference will be sent to you by the clerk's office in the mail. So with that, you are free to hang up from the court proceeding this morning. Be expecting your next court appearance date in the mail, okay?
Yes, sir.
File 260367 SM, People versus Daniel Edward Lutker. Mr. Lutker is here for arraignment this morning on an appearance ticket that was issued by the Wayland Police Department on a charge of furnishing a tobacco product to a minor. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Lutker for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading, and Mr. Lutker will be pleading guilty today, Your Honor.
And sir, if you do that, you will not have a trial today. And I have to inform you, first of all, that this is a misdemeanor charge, not a civil charge. It's an actual misdemeanor charge, but it does not carry the possibility of any jail, only fines and costs. Knowing that, he is still wish to plead guilty to the charge of furnishing a tobacco product to a minor.
Yes, sir.
On February 10th, you signed this yellow advice of right sheet. Before you did you read and understand all those rights?
Yes, I did.
Those are your trial rights. If you do plead guilty, you will not have a trial of any kind. You will give up all those trial rights. Do you understand that?
Yes, I do, sir.
Has anyone promised you anything regarding what your sentence will be if you do plead guilty today?
No,
Anyone threaten you to force you to do this?
no.
Is it your choice to plead guilty?
Yes, sir.
And are you pleading guilty to this charge because you believe you're guilty of this charge?
Yes, sir.
The appearance ticket states this occurred on January 31st of this year at about 1:30 in the afternoon at 150 North Main Street in the city of Wayland here in Allegan County. Is that a commercial establishment?
Yes.
And which one is it? Is that the gas station there?
Yeah, it's Wayland BP.
And were you an employee of Wayland BP?
Yes.
On that date at that location, did you sell a tobacco product to a minor?
Yes.
What did you sell?
Pack of cigarettes.
And how old was the person you sold to?
To be honest with you, I have no idea. I was not informed of that.
Well, you are trying to plead guilty to furnishing a tobacco product to a minor. And if you don't know the person's age, I won't be able to accept the plea. So, Mr. Badger, do you have anything else you can help me with there?
Mr. Lutker, what did the officer inform you of when he came and spoke to you?
Actually, what happened is he came in. I was very busy, not an excuse, and I sold him a pack of cigarettes. I was out in. Then a few minutes later, a lady walked in with him. She threw down a pack of cigarettes and the money on the counter and says, "I sold to a minor." Never identified herself or anything.
Okay, let's set this for a pretrial then, Mr. Badger, because he has to sell to a minor. We don't know for sure. He doesn't know. So at this point, Mr. Lucker, based on what you were telling me, I'm not going to be able to accept a plea. Perhaps once we get a police report, we could do something else. But at this point, I'm guessing your office will not be representing him because there's no jail possibility.
That is correct, Your Honor.
So, Mr. Lutker, based on what you're telling me, since you don't know that you sold to a minor, we don't have any proof at this point how old the person was you sold to. Doesn't sound like you looked at any ID to know how old the person was. So in any event, I'm not able to accept a plea. We're going to set this for trial. The public defender's office will not be representing you in this case, which leaves you with two options. You can either hire your own lawyer or represent yourself. Do you intend to hire your own lawyer or represent yourself?
I would just represent myself.
If the case is not resolved and is set for trial, would you like your trial before a jury or before a judge?
A judge.
When a not guilty plea, set this for a non-jury trial, indicate the public defender's office will deny representation on this case. We'll set bail on this at $200 personal recognizance. Case will be set first for a pretrial conference with the prosecutor's office. If not resolved, it will be set for a non-jury trial in this courtroom, District Courtroom A. Court staff is going to mail to you the date and time for your pretrial conference, and that is when the prosecutor's office will call you and discuss your case with you. They'll have additional information such as police reports that we don't have here today. So with that, you are free to hang out for the court proceeding. Be expecting your pretrial conference date to be sent to you in the mail. Okay?
Thank you, Your Honor.
Two files here, actually more than two files. Three files on Trevor Paul Schmidt. These are on charges of operating an uninsured motor vehicle, operating in a vehicle without a registration certificate, and driving without having a valid operator's license. Mr. Badger, please.
Sam Badger appearing on behalf of Mr. Schmidt for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering pleas of not guilty, and he does qualify for a court-appointed attorney. And so we would request that these matters be set for a pretrial conference and a jury trial, Your Honor. Thank you.
On the charge on file 254314SM, charge of operating a uninsured motor vehicle. Enter a not guilty plea, set this for a jury trial, indicate you're requesting an attorney at public expense. We'll set bail on this file at $1,000 personal recognizance. Condition of bail on this charge that you not operate this 2002 Chrysler until you obtain valid Michigan insurance on that vehicle. This case will be set first for a pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. Public Defender's Office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your pretrial conference. On the second and third files, driving without having an operator's license and not having valid registration in the vehicle, we'll enter again on those two files, not guilty pleas. Each of these two cases will be set for jury trials, again indicating you're requesting an attorney at public expense. On each of these two files, we'll set bail at $500 personal recognizance, same condition as the first file. Each of these two files will be set for pretrial conferences with the prosecutor's office,
And that's the end of that. Just pull the feed on no notice whatsoever. I love judges sometimes. Good morning, everybody. Happy Monday. Welcome to TCF Live. Good to have you all here with me. Let's stay in Michigan, but we'll go say good morning to Tony Flores.
Right, so we're on the record in docket 250326, 03626. That is People of the State of Michigan versus Nicole Fitzgerald. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
And who's from the, who's representing Ms. Fitzgerald?
Autumn Luce here on behalf of Jack Rucker.
And how do you spell, oh, okay, so, and how do you spell your name, ma'am?
My name is Autumn, Autumn. Last name is Loos.
Loos. All right, this is the time set, and ma'am, you are Nicole Fitzgerald, is that correct?
Yes, sir.
All right, thank you. This is the time set for a final pretrial in the matter. Ms. Fortuna Gill, how are we proceeding?
Your Honor, we do have a complaining witness present. We would ask that this matter be set for jury trial.
And we'll set for jury trial. We're using a March 16th date. I don't know if that's still.
We can't do March 16th. That's the inventory date.
Okay.
So it's either
It's good.
the 23rd.
The 23rd. So we'll do March 23rd at 8 o'clock.
The final pretrial start at 8:30 on schedule.
This is a final pretrial.
Or, oh, yeah, sorry. Yeah.
So we will be set for jury trial on March 23rd at 8 o'clock. And anything else for the record in docket 2503-626, Ms. Fortuna Gill?
Not for the people.
Ms. Luce?
Just for the record and for record keeping purposes, what day would all motions, pretrial statements and all of that be?
They're due, the jury instructions are due the week before. And that's usually when we look at any type of motion or anything, at least set it for hearing.
Okay.
All right.
Thank you.
Anything else, Ms. Luce?
No. That's
All right, you should be all set, Ms. Fitzgerald. Thank you for your appearance today.
Your Honor, if we could go on Amon, that's the co-defendant.
William Amon.
Yes, Your Honor.
All right, so we're on the record in 2503-426. That is People of the State of Michigan versus William Amon. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. William Amon Sr. He is standing to my right. Mr. Amon, if you could please state your name and apologies. If you could please state your first and last name for the record. William Amon.
Thank you. This is time set for a final pretrial in the matter. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. Similarly, we would ask that this be set for jury trial. We would ask for that same date.
All right.
Yes, Your Honor, that is correct. At this point, we would be having this case set for jury trial.
All right. So we set for jury trial on that same date, which is March 23rd. At 8 o'clock. All right, we've left this on for jury trial on March 23rd at 8 o'clock. Anything else for the record in 2503426, Ms. Fortuna Gill?
I already have informed the court, but since this is a separate record, I would like to say on the record that the complaining witness is present today for the final pretrial.
All right, thank you. Mr. Harris.
Nothing further defense, Your Honor.
All right, Mr. Amon, we'll see you on March 23rd at 8 o'clock. Thank you for your appearance today.
Thank you, Your Honor.
Where did you want to head next, Ms. Fortuna Gill?
We could handle Frenchie Pearson.
All right.
Yeah.
Right, so we're on the record in docket 2503714. That is People of the State of Michigan versus Frenchie Pearson. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Smith.
Tyler A. Smith, in the Office of the Public Defender here in Ingham County. I do appear on behalf of Mr. Pearson, who's standing to my right.
And sir, you are Frenchie Pearson, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a jury trial in the matter. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. I believe this was a case that was amended from a felony file to a misdemeanor file. And so I think that is why this matter is set for a final pretrial and a jury trial on the same day.
All right.
Regardless, we do not have a complaining witness present. I am not surprised by this. My office has tried to get contact with her and has been unsuccessful in doing so. I anticipate a motion from defense counsel.
Thank you. Mr. Smith.
Yep, I would respectfully request the court to dismiss the matter at this time. It appears necessary witnesses are not interested.
All right. All right. Based on the prosecutor's representations, the complaining victim has failed to appear. They have been subpoenaed and any contact has been unsuccessful in order to get them to appear. I will grant the motion for dismissal without prejudice. Mr. Pearson, this means that people could reissue if they choose to, but for our purpose today, the case is dismissed. All right, sir? All right. I'm going to have that printed out. Thank you, Megan. I'm in possession of the Nolly Pross on 2503714, the Nolly Pross or order of acquittal. And based on the defendant's motion to the court without prejudice, I will sign the Nolly Pross. There is a no contact order, so you should keep, I should get a copy of this from my court officer. You should keep this with you because it takes about 4 hours to purge from the system. And there's also a GPS, so a GPS tether order. So we will contact the private agency, and I think they put it on right next to the sheriff's department. Is that? Yeah, so that's where it'll be taken off, right at the same place they put it on. And you should carry this with you just in case, because it takes a few hours. All right, I will sign this. Anything else for the record in 2503714, Ms. Fortuna Gill?
Not for the people. Thank
Mr.
you.
Smith?
Nothing for the record, Your Honor.
All right. You can get a copy made of the order of acquittal. Thank you for your appearance. You're all set, Mr. Pearson.
Thank you.
Garza?
Mark Garza?
Yes, please.
All right, so we're on the record in docket 2503563. That's People of the State of Michigan versus Mark Garza. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Harries.
Assistant Public Defender James Harris here on behalf of Mr. Mark Garza, who is standing to my right. Mr. Garza, if you could please state your first and last name for the record.
Mark Garza. Thank you, sir. This is the time set for a final pretrial in the matter. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people would like to dismiss this case. We've received further information that leads us to want to dismiss this file in the interest of justice.
All right.
The defense would have no objection to the people's motion to dismiss in the interest of justice. I would simply request that a copy of the dismissal be provided to my client.
All right. So we will copy, we will have printed out a dismissal at the request. So it's, I would, for purposes of interest, a dismissal of Mr. Garza. It'll go to Haley to sign. So we're on the record, and I'm in possession of the Nolly Process order of dismissal on 25-03563. Since signed by the prosecuting official, I'll sign this. I don't have any, so you can keep a copy of this for your records if you want. It takes about 4 hours to purge from the system. I have no contact. I don't have any contact, no contact order or GPS. But if you want this, we can make it available to you. Anything else for the record in 25-03563, Ms. Fortuna Gill?
Not for the people.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, thank you. You're all set, Mr. Garza. Thank you.
We're going Harhut.
Sure.
We can go on Harhut.
Harhut. All right, so we're on.
So I need to interrupt for a minute because it's a choose your own adventure moment here at TCF. So Judge Simpson just started a bench trial. Now we can tune into this bench trial, but note a couple of things. I have a hard out at the end of hour 4 today. I cannot go long. So if for some reason it doesn't finish, sorry, but there's nothing I can do about it. But we could watch that because bench trials are always interesting and Judge Simpson is always interesting. Or we could do our standard flip around, check a bunch of courts out. I'm going to put up a poll. You guys let me know what you want to do and then we'll work accordingly. So hang tight while I put the poll up.
That would be with a sentencing agreement to 7694A, an agreement to no upfront jail, in addition to an agreement with mental health treatment to be a part of the probation process. And in return, upon successful plea and sentence, the count 3 and count 1 would be dismissed.
That is a correct statement of the offer, Your Honor. My understanding, Mr. Smith was able, from my office, was able to speak with Mr. Harhut regarding that offer before I got here this morning. And my understanding is Mr. Harhut is willing to take that offer at this time. And he did confirm as much to me once I got here and spoke with him.
All right, so did you want to add a count or amend the count? Amend the count. Well, let's add a count.
Okay, I was gonna say whatever's easier for the court.
I don't know anymore. Add count 4 of domestic violence. And what's the PAT code for that?
Yes, Your Honor. The PAT code for that is 750.
All right, 10 votes in a minute. 100% of you want to watch the Simpson bench trial. So that is where we will go. We will stick with it for as long as it goes, for as long as we can, or until Judge kills the feed or whatever happens. But let's go there. Judge Simpson.
Court does call the case of the people versus John, is it Versavi?
Alexander on behalf of the people, Your Honor.
Good morning, Your Honor. Dan Garrett, I believe it pronounces it Resavi, is that correct, John? Resavi, Your Honor.
Resavi, got it.
John Resavi.
All right. Meeting time set for trial, are we ready to proceed?
Before ready, Your Honor, I did want to put on the record that there was a previous offer to be discharged with sentencing under 7694, and it's my understanding the defendant is rejecting the offer.
So now she is, Your Honor, and we are ready to proceed as well. Thank you.
All right, very good. Opening statements, or are you waiting?
I'll do it short, Your Honor.
Pardon?
I'll keep it short, Your Honor.
All right, very good.
Your Honor, today we're here, it's been a trial. Today, the court will hear testimony from D'Angelina Terrell, who the court will hear was in a relationship with Mr. Savvy. They have 2 children in common. The court's going to hear from Mr. Terrell the events that occurred on September 24, to include an incident with Mr. Savvy where she was pushed after trying to put their children to bed. And I believe at the end of this testimony, the court will see her testimony, see her demeanor, and find the defendant guilty beyond a reasonable doubt.
All right, very good. Skinner, would you like to give an opening statement, reserve, or waive?
I'd like to give one, Your Honor, very quickly. Your Honor, this case, as you heard counsel say, goes all the way back to September of 2024. At that time, my client, Mr. Resavi, was and is a veterinarian, a National Guard veteran. He was living in Pittsfield Township, sharing custody with the complainant, Ms. Terrell, of 2 children that he thought he was the father of, and later learned that she had lied to him, was not the father at all, which I think will reflect on her credibility, which is clearly going to be an issue in this case. But nonetheless, they shared custody at that time, 50-50. He had the kids, and he invited Ms. Terrell over. You're going to find that their relationship was toxic, probably at best, but they still did sometimes hang out. And that night they were planning on hanging out a little bit, so we invited them over. The kids would not go to bed, being rambunctious because mom and dad were together. It was getting late, so John told her, "You got to go." Over the course of about 45 minutes, he kept saying, "It's time for you to go," for lack of a better legal word, revoking her ability to be in his apartment. She told the police she protested. She didn't want to leave. She wanted to hang out with the kids, and that caused some friction. As for what allegedly happened, Your Honor, my client will tell you that as he's standing in the doorway saying, "I'm going to get your purse, it's time to go," she loses her cool, smashes by him, pushes him up against the wall where he smashes his head and shoulder against the wall, leaving a divot in the wall and redness on his head. She runs, grabs the phone, and calls police. Now, what she tells police, Your Honor, is that he pushes her and that he smashes his own head against the wall, which I think the physical evidence, my client's testimony, and he will testify in this case, will definitely belie that. I'm hopeful at the end of this case, you'll find that this was toxic and this was immature, but this was not criminal, especially at Mr. Resavi's hands.
Very good. May I call your first witness?
Thank you. People call D'Angelina Terrell.
So while we wait for that witness to come up, good morning once again, everybody. TCF Live on a Monday. The crowd has spoken. We are watching a bench trial with Judge Simpson. Normally we move from court to court, but we're going to follow this and see where it leads us.
And please come forward to be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
See, state spell your first and last name correct, please.
D'Angelina Brennan, Beangelena Brennan, but my former last name is Terrell.
Go ahead, you may inquire.
Thank you, Your Honor. And you go by Lena?
Yes.
Lena, do you know a John Rasavi?
I do.
How do you know him?
Bartender when we were both living in Manhattan, Kansas.
Did you have a relationship?
Yes, it was one of friends with benefits. I got to like a romantic relationship.
So you had a kid together? Okay. If you saw John today, would you recognize him? Is he in the courtroom right now? Can you identify something he's wearing and where he's sitting? And where's he sitting?
On the left side, the courtroom to the farthest left.
Okay. Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shall so reflect.
So I'm going to direct your attention now to September 24th of 2024. On that date, were you at 3341 Primrose Lane? And is that in Pittsfield Township,
Yes.
County of Washtenaw, State of Michigan? And on that date at that location, did Mr. Rice-Savvy do anything to you that made you call the police?
Yes, so, he had asked me to leave after, coming against the bed, and I was trying to do so, but I didn't grab my purse. And as I was walking to grab my purse, he had cut me off and started pushing me more towards the stairs. And, it was like, I don't know how long it happened. I just knew that I started hearing the kids cry. And I told John, I was like, hey, the kids are watching their phone. We kind of sound elements. And then the walls were up.
Okay, so let's kind of start back at the beginning. Whose residence is that?
It's John's residence.
Okay, and how did you end up being at that residence on that day?
On that day, I had went to class and we were in the middle of a quiz, so they said, you had worked on that. And he had asked me to pick up a target order that he had placed that was ready. And I told him I would do that. And she spoke on the phone. I asked him if the kids would probably like to know, because I didn't want to go inside. Because I knew that my presence would like rile them up. And I didn't want to stir them up right before bed. He told me they were sleeping. I had a clicker to his garage because it was kind of like a townhouse condo situation. So I opened the clicker and before I could even open the door, our eldest son, Alexander, opened the door. And I told John, because he was standing there, I was like, don't worry about it, I'll just put him to bed for you. And then we could like kind of talk later, because the whole point of me being there was to talk. I forgot that part, but we were just gonna hang out and talk.
So then, sorry to cut you off. So you got it there. Kids are awake. You go in the house and you're going to put them to sleep.
Yes, I told him I would put, well, at the time I thought it was just one son, but then I saw the other son was awake too. So I said, I would put two sleep. And we could talk later. I was in the middle of putting Arthur to sleep. Alex had fell asleep. And John had came in, and he was just saying, like, they don't do this while you're here. It doesn't go like this. They're only doing this because you're here. And I told him it was fine because Alex had just fell asleep and Arthur was on his way to sleep, like, you know, just give me like 30 minutes. And Arthur should be asleep. And the second time he came into the kid's room, that's when he asked me to leave. But at that time, Arthur was like 2 seconds away from actually like being into deep sleep, and I asked him if I could stay just a little bit, just so he could fall asleep, and then I'll leave. And he was like, no, you need to leave now. And I was like, okay, fine. And the way he was standing in front of the room entrance. And so I was going that way, and he was like, no, you need to leave to the bathroom. But the way that their door is set up is like, when their room entrance doors open, it blocks the bathroom doors entrance. So I moved the door
The hallway door?
The entrance to the room door. To get into the bathroom, because the bathroom cuts out into like the little hallway that his house has. And so when I did that, he was like, "Bitch, did you just try to close the door on me?" And I was like, "No, I'm just trying to leave." And then he cut me off as I was trying to get to the kitchen to grab my purse and stuff. And that's when he started pushing me. And I kind of started pushing him off of me and asking him to let go of me. And he wasn't trying to let go. He was like, "No, you need to leave, you need to leave, you need to leave." And I was like, "I'm just trying to leave." I was like, "I'm just trying to grab my purse." And that, I don't know how long that went on. I would maybe say like 2 to 3 minutes of him trying to push me and me trying to like get him off me, because the way that his house is laid out, there's like a small, short set of stairs and then a very long set of stairs, and tile at the bottom of those long set of stairs. And in that moment, I was scared that he was trying to push me down the stairs. Because that's how badly he wanted me to leave. And like I said earlier, the only reason why he like kind of let go of me is because I said, "Hey, John, the kids are watching, they're crying." And they were, and they were really scared. And I called the police. And as I told John I was calling the police, that's when he decided to hit his head against the wall and said that I hit him. I was nowhere near him at that time. I was like as far away as I could be trying to call the cops.
So how did this whole incident make you feel?
It made me feel scared because like John and I have gotten into fights before. But like I never felt like my life was in danger. I think that was the only time I was like, "Wow, this man's really trying to hurt me." And I couldn't even tell you like what I did wrong to even make him want to like try to.
Your Honor, may I have one moment? And I know you mentioned your 2 sons. Are those 2 sons you share with Mr. Rysavvy?
Yes,
So he is their parent?
yes.
Okay.
Alexander isn't his biological son. That's something we found out later down the road. But not at the time of the we found out, well, John did a DNA test on Alexander, like a month or 2 after the incident happened. And found out that he wasn't his biological son.
Okay. And that's the older one?
Yeah, that's Alexander.
And the younger one?
He's Arthur.
And was the same testing done?
I just only know the one for Alex and not Arthur.
Okay. All right.
I have one more moment, Your Honor. Nothing further to this witness, Your Honor.
All right, cross-examination.
Thank you, Your Honor. Mr. Brennan, good morning. Let's start with the location at Primrose Lane. That was Mr. Rysavvy's house, yes?
Yes,
You were not on the deed, you were not on the lease, you were not on any sort of documentation, correct? You had your own house or location elsewhere, yes?
yes.
So I think you told the judge and the prosecutor, he told you to leave several times, yes?
He only asked me to leave once. And then when I was trying to grab my purse, because it was in the kitchen area, that's when he was like, "No, you need to leave," but I can't leave without my keys or my wallet.
If I heard you correctly earlier, I think when the prosecutor was asking questions, you said, and I quote, "Give me 30 minutes." Is that correct?
Yes, for the kids, because he didn't ask me to leave at that time when he came in the first time. He was just getting agitated, saying that they will do this while I was here with me.
So if you're asking to give me 30 minutes, what are you asking him to do? What?
I said, give me 30 minutes so I could finish putting our youngest son Arthur to bed. Because the whole point of me being there was to talk and hang out.
Okay, so give me 30 minutes is in response to him telling you it's time to go.
Didn't ask me to.
You use the word with the police, so I think Officer Branch is here over my shoulders, that you protested. I think that was your word on the video, correct?
I didn't protest, I just said that I wanted to finish putting them to bed because I was there and I knew the moment I left, it would rile them back up.
Do you recall using the word protest to the officers? I protested for 30 minutes.
Say,
Ma'am, with respect to a 911 call, what was your intention in calling 911?
well, one, I still haven't had my purse at the time to leave. So that was the, and the other intention was so that I could be able to leave safely, because at that point, he just put his hands on me, he just tried to push me. I just wanted to leave.
So I'm curious, then, why is the call and the about him smashing his head in the wall repeatedly? Why are you telling the dispatchers that?
Because he just did that as I was calling them. Like the moment I said I'm calling 911, he started hitting his head against the wall. And that was very confusing to me. And so I let them know because I wasn't near them. In fact, the kids were the closest to me. And I informed them that that there were kids present and that what had happened was that he was trying to push me.
I mean, you guys had a custody arrangement at that time, correct?
Yes,
It was 50-50, correct?
yes,
In response to the question I think the judge asked you, you had told Mr. Rasevi that Alex was his child, yes?
yes,
And he was paying support for him, yes? Continues to, yes? You had the children 50-50. This was his night on September 24th, 24, correct?
well, so that's a little tricky because custody agreement actually states that on Tuesday, I pick up the kids from school. But because I was going to school at that time, I had asked him if he could additional.
So whose night was it on this night?
It's technically mine.
Okay. And this particular night, you guys had 50-50 custody, correct? Did you seek to try to change full custody after this?
Not full custody, but I definitely felt like after this incident, John's behavior has grown increasingly concerning. To the point that the kids were coming and telling me very concerning things.
Now, Ms. Brennan, when you first gave the story to the judge, you said that my client had sort of his hands up and was stopping you from coming back into the apartment. Is that accurate?
I wouldn't say accurate. He actually like was pulling me by my shirt and then pushing me by my shirt, if that makes sense.
Did you have any sort of stretched out shirt, any marks, any injuries, anything that you could show the police to what we call corroborate that?
I don't think so.
Did you have any injury whatsoever?
No.
To your knowledge, did you see injury to Mr. Rasevi's head?
No.
But of course, your testimony is that he put his own head into the wall. Is that correct?
Yes.
Okay. I have no further questions.
I guess I'm trying to figure out. He asked you to leave, right? At some point.
Yeah, he asked me to leave and then
But what was your response to him asking you to leave?
my response was, can I just finish playing Arthur that he's almost asleep?
Is that the give me 30
No, that's not the give me 30. That
Okay,
was-
so when does the give me 30 come?
That was prior, that was the first time he came to the room. He didn't ask me to leave. But he was getting agitated and saying that they don't do this while I'm here. And I just told him, give me 30 minutes and I'll be done. Putting them to bed. Because
And so how much time had passed before that comment and then him asking you to leave?
I wasn't aware of the time I didn't see, but I feel like it wasn't 30 minutes. It was definitely less than that.
When you said give me 30, what was his response?
He said, okay, and he closed the door.
And then at some point came back?
Yes.
So when he asked you to leave at that moment, I guess my question is why didn't you leave?
Because Arthur was still awake. His eyes were closed, but he was still awake. And I knew if I were to have gotten up, that would have just like kind of reawakened him. And that's when I was like, really just finished with him. So, and then I'll leave. And then he was like, oh, he needs to leave down. I was like, okay.
Okay, so that was 2 times that he's asked you to leave, because he said he asked you to leave,
Yes.
you didn't right then, right? And then he said, no, you need to leave right now.
Yes. And then after he said that, I was like, okay, fine. I'll leave. But then what I think kind of escalated the situation when I was trying to leave out of the bedroom entry door. He told me not to do that. He told me to leave.
Where was your cell phone?
I think it was in my hand at the time. Because I had it in the room with me and the kids.
Okay. And then when you exited out, did you exit out the bedroom door or the door that leads to the hallway through the bathroom?
The door that leads to the hallway through the bathroom because he was standing in front of the bedroom.
Didn't ask why, but that's the door you exited out of.
Yes,
How far is the stairway from that door?
I would say that.
Okay. And then did you head down the stairway?
No, because I didn't have my purse in the room with me when I was putting the kids to bed. It was in the kitchen area on like the little countertop.
And is that on the lower level?
No, that's on the top level.
That's on the same level as the bedrooms?
Yes.
Okay. And so you said, let me get my purse. And then you went to get your purse?
I was trying to, but that's when he cut me off before I could even grab my purse. They started like pushing me more towards the stair area. Where the door would lead to. Like there's a short set of stairs, like 2 or 3 steps. And then there's a long flight of stairs after that. That leads to like the door.
Did you ever get your purse?
I did, once the police were there.
So prior to that, you didn't get your purse?
No.
So did you leave the building?
I went down the stairs.
So you called the police from upstairs?
Yes, because after he let me go, I was able to call the police. Because I was trying to get his hands off of me, so he wouldn't push me down those stairs.
Can I ask you, if you had your cell phone with you and he wasn't letting you get your purse, why didn't you just leave? And then, as you did, call the police from outside or wherever and ask them to come so you could retrieve your purse?
Because I didn't even get that opportunity. Like, once I went to the direction of my purse and he cut me off, that's when he started pushing me. And that's when the whole altercation.
No, what I'm saying is, okay, that happens. So why didn't you then turn, go down the stairway, go outside, call the police to then get your purse?
Cause he was holding on to me, like, he wasn't trying to let me go. I didn't have the opportunity to even like to fully even push him off of me so that I could even go down the stairs. The only reason why he let go is because the children saw what he was doing. And then after that, I went downstairs. Like, I called the police, I started heading downstairs, getting my stuff on, and the kids too.
So there, Mr. Guerin had asked you about a custodial arrangement. And so this was a school day?
It was a Tuesday night.
Okay. And so the 50-50 arrangement at the time was what?
It was, so it was like Friday evening, Saturday, Sunday. Saturday, Sunday, every other weekend. And then.
Stop.
Sorry.
When you say every other weekend,
Right.
for him?
Yes, for him, it was every other weekend. I have a weekend, he has a weekend, so we do 2 weekends for kids each month.
And then what happens during the weekday?
The weekday, he has them on Monday and Tuesday.
And this happened on Tuesday.
Yes.
So why do you say that was your day?
Because the way that our original agreement was laid out was that he has them until Tuesday morning, and then I pick them up in the Tuesday afternoon.
Well, that won't work because really the agreement would talk about overnights, right?
Yes,
So who had custody that Tuesday overnight? Look at what day of the week, September 24th.
yes. I did. It was my night, but I had asked him to take care of the kids because I have class in 3, so I wouldn't be able to take care of.
So suffice it to say, despite the agreement that when you requested that of him, he was to then take care of the kids.
Yes,
And they were going to stay that Tuesday overnight.
yes.
And then again, why were you there?
Why was I there?
Yeah.
I had asked John, and then he also had asked me to pick up his target order because he has 5 controllers for the kids, and I said that's fine. That I would do that.
Oh. So you asked him to hang out.
So, yes.
So all of this, what time were the kids being put to bed?
I didn't get to his place closer to like 8:30, 9 o'clock-ish. I don't remember the exact time, but I know it was like late.
And had you picked up the target order?
Yes,
So it was 8:39. What time was during that time the kids' bedtime?
I don't know how he has their bedtime structured at his house, but mine is 7 o'clock.
Okay, were they in bed when you got to his house?
One of them wasn't Alexander, the oldest one,
How old is he at the time?
he was about to be 6, and he was 5.
Okay.
He was 5, and he was up. He had opened the garage door for me before I even opened it.
Okay. So at some point, but I mean, they're dressed for bed.
Yes, they were dressed for men. But I had informed John to let me know if they were up, because then I wouldn't have to, I wouldn't really be inside. Because I knew that I would roll them up. He was assuring me that they were in bed. Right. And so when they saw me, they're like, oh, mom's here, mom's here. So that's when I was like, oh.
Any questions based on the court's question?
None from the people you're asking.
Nor do I, thank you.
Just step back. Call their next one.
People no further witnesses, Your Honor.
All right. Witnesses for the defense.
Your Honor, this time we would call John Reserve, please.
Clerk, please come forward.
See, raise your right hand. You solemnly swear to affirm the testimony about you will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
So have a seat. State and spell your first and last name.
John Reserve, J-O-H-N, R-Y.
Inquire.
Thank you, Your Honor. Mr. Reserve, good morning. Ask you, do you remember the events that occurred, did or did not occur on September 24th, 2024 at 9:40 p.m.? Just going to ask you point blank that night, John, did you aggressively push Miss Terrell Brennan at any time that night? Did you aggressively grab her sweatshirt, tug her sweatshirt, pull her in any way? Did you, I know it's a legal term of art, do you believe you assaulted her in any way? Were you violent towards her? Did you intend to harm her? Did you threaten to throw her down the stairs? Did you smash your own head against the wall? We're going to talk about all that in some details. Let me ask you a couple questions about you, sir. How old are you? And at the time, I'm guessing, what, 32 or so, yes? What do you do for a living? How long have you done that? I mentioned you're also a military veteran as well. What branch? Are you still in that or no? We heard some questions about Miss Terrell Brennan and your relationship with her. You two were never married, correct? Just very quickly, did you believe you had 2 sons with Miss Terrell Brennan? When did that change for you?
In November of 2020.
And we heard some talk about a DNA test. Did you take a DNA test?
Yes.
Was that self-initiated?
Yes.
And did it, in your mind, prove that the oldest Alex was not your biological son?
Yes.
Had Miss Terrell Brennan previously told you that he was?
She did.
Did she fight that he wasn't your son at that time?
She refused to believe the first test.
At the time of September of 2024, is it accurate to say the two of you had a 50-50 custody arrangement?
It is.
Heard the judge ask us some questions. September 24th, do you recall if that was your night, Miss Terrell Brennan's night, or you don't recall?
I don't recall.
Okay. But were the children at your Primrose address?
They were.
I asked her that she had Miss Terrell Brennan had a separate apartment or separate location, yes?
Yes.
I want you, from your own perspective, to tell the judge what brought you two together that night.
We were going to have sex.
And who initiated contact?
She did.
And so was the plan to meet up after the children were asleep?
It was.
And do you recall what time she arrived?
It was approximately 8:30.
Were the boys sleeping at that point?
I thought
Okay. They were in their rooms?
Yeah.
And so what happens after Miss Brennan arrives?
I go downstairs to greet her. When doing that, Arthur, our youngest, was the one that woke up. And then Mary, she went to go to bed.
Okay. And I guess I'd ask you from there, did the night start to change a little bit?
After waiting for, I wanted to get to that because I wanted to get to that.
And you said waited for what?
For her.
Okay. At any point, Mr. Rezavi, did you ask Ms. Brennan to leave? How many times would you say you asked her to leave?
What I did over again. Probably at least 10 times.
Getting back into your mindset, why were you asking her, telling her to leave?
I wanted to go to bed. I was tired. I wanted to get the kids to bed because it was gonna be early morning.
And you said, asked her many times, did she agree?
When I told her actually to leave, she stormed out the bathroom door. Was starting to go downstairs, turn around, told me she needed her stuff. I told her, I'll grab it, leave. She continued and tried to force her way through me. I held my ground with that. And then during that, I had my hands up and locked myself. My hands pushed down. I snagged my thumb on her hoodie, at which point she yelled, "Don't fucking touch me." And then she began to hit and shove me. And then I started, retreating on back about 8 to 10 feet.
All right, lots to unpack there. We heard some conversation from her earlier that she said, give me some time, give me 30 minutes. Do you recall that statement? Okay. You said a second ago to the judge that you said, I'll get your stuff. What stuff were you going to get for her?
She had her purse. She also had a water bottle that I didn't realize she had brought with. She received that. So the purse I gave to her when she finally decided to go down the steps. I grabbed it, tossed it in a little square where the stairs changed direction for her to grab. I didn't realize she had a water bottle. Police told me that it was still there, so I gave that to them, and then they returned it to her.
All right, if we can back that up a little bit. At what point did you give her the purse back?
After she was shoving me, I hit my head. She called the cops, and then she left. So I went to grab it.
Okay. Going back in time, when you say you'll get her stuff, why did you not want her coming back into the guts of the apartment?
She's taken these before. Did a ring?
Did you say a ring? And so when you tell her you'll get it, does she allow you to go get it for her at that point?
She would not. She told me to do it herself.
Okay. I want to ask you about the physical contact in very specific detail. I know I asked you this from the start, but did you sort of stop her physically by putting your hands on her?
I put my hands up. She was the one that was coming to me.
You indicated a second ago that your head hit the drywall. Can you tell the judge exactly where that occurred, how that occurred?
So everything started near the edge of the stairs. After she started pushing and shoving me about 10 feet, 8 to 10 feet. From there, I ended up losing my footing and my head hit the wall along the shoulder.
Okay. Do you recall what shoulder it was? Okay. So your right shoulder and your head, what side of your head hits the drywall? Did you do that of your own intention? Did you do that on purpose? Did you knowingly smash the side of your head into the wall? You said you lost your footing. Was that after she, you believe, touched you in some way?
Yeah, she was in the process.
I'm going to ask you about sort of damage in both respects. Did the wall become damaged? And did your head or side of your head become injured in any way?
It was red. I had a bit of a headache.
maybe short circuiting a little bit, when the police arrived, I believe it was Officer Branch, who's over my left shoulder, did one of he or his partner take pictures of this scene?
They did.
Did you get pictures of the damage as well as to your head? Here, I'm holding what I will mark preliminarily, if possible, as Defense Exhibit 1 or A. This is a picture that was in discovery, and I wonder if I may approach the witness with it. Okay, thank you. Mr. Arcevi, I've handed you what's been marked as, for identification purposes, Defense Proposed Exhibit A as an apple. Do you recognize that picture? And can you tell me what that picture or those pictures are?
One is of my forehead, the other is.
And do those pictures accurately depict what you recall them looking like, whether it be the wall or your head on September 24th, 2024?
Yes,
And is the top picture the damage to the wall?
it is.
Had that damage been there prior to the altercation between you and Miss Terrell? The picture of you, are you able to see any injury, redness on your head in that picture?
I am.
Was that injury or redness there before the incident with Miss Terrell? And do you believe then that those pictures accurately depict what happened to the wall and to your head that night?
I am.
Or I'd move for admission of Defense Exhibit A.
Any objection or voir dire? Exhibit A is admitted.
Thank you. Mr. Arcevi, as I sort of finish up here, I want to talk about the call to the police. Where was Miss Brennan when she called the police?
She was in between where I hit my butt, in between stairs and where I hit my head. So near the bathroom door.
Did she have a cell phone with her?
She did.
I guess, some questions about, asked her how she felt. How were you feeling at that moment when she was calling the police?
I was in shock.
Shocked because of what happened? Shocked because she was calling the police, or both?
Of what happened.
Now, I asked you some questions about the police arrival. Either Officer Branch or Escobar from Pittsfield did respond to the scene, yes? Did you cooperate with them to the best of your ability? Tell them essentially everything that you could remember about the incident? And were you honest with them? Okay, and honest with the judge today? Okay, Your Honor, I have no further questions.
Examination.
So, Mr. Ricevi, you mentioned, am I saying that right?
It's recipe.
Recipe? Recipe, okay. So you mentioned an incident in this narrative you put of someone hitting you, shoving you, you snagging your thumb on her sweater. Is that correct? Did you mention that to the police when you made the initial statement? And you mentioned also your shoulder from falling into the wall. Isn't it true that you told them that was hurt from something else previously than this incident in the body cam? Wait one moment, Your Honor.
Sir, the layout of this location, is everything upstairs?
So the garage is below. There's the door and the stairway goes up to it.
Gotcha. Okay. And was the person in the kitchen area or, well, where do you think, where was her purse located?
The purse was in my bedroom.
So it wasn't in a kitchen area? Did you tell her to leave through the bathroom?
I didn't tell her specifically to leave the bathroom.
You didn't what did you tell her?
I told her to leave, and then she got very angry.
Between the two of you, physical contact between the two of you took place in the hallway area? Is that correct?
Correct.
Were you not supposed to have the children that day? Do you recall?
I didn't recall.
You don't recall? All right. After this, was there then any other like family court actions or anything that occurred between the two of you?
March, we had front of the court hearing, and then it's March of 2025, September of 2025.
Okay, leading up to the March hearing, how was that initiated? What happened?
She initiated it after I was not being biologically mine. I was saying less than kind words about her.
Okay, so incident happens at the end of September. Sometime in November, there's the DNA test.
Correct.
All right. After the DNA test, then within 3 to 4 months after that, you guys are back in court.
Yes.
That hearing, from your perspective, what was the purpose of that hearing?
She wanted to adjust the parenting time.
Both or for what? Adjust it from 50-50?
Yes, from 50-50 to our current arrangement, which is every other weekend. She has them.
Say again?
I have them every other weekend. She has them the rest of the time.
So she wanted it adjusted from 50-50 to basically a 65-35.
Correct, yeah.
During the course of those, you actually had a full hearing before a referee? All right. Did you have a hearing before the judge then?
No.
Did this case or this incident become a subject matter of that hearing at all?
I didn't know it was brought up.
Pardon?
It was not brought up.
It was not brought up. Okay. You didn't require any medical care, meaning the hospital or anything like that, right?
When I was arrested, I did go to the hospital when my blood pressure was.
Pardon?
I went to the hospital after being arrested, my blood pressure.
For blood pressure. So prior, it's gonna sound like a strange question. Prior to this time, to this September 24th day, were there calls like this before for you guys to get together to have sex or?
Never.
There were? Would that occur always at your house or at her place, or how would that work?
Primarily.
Pardon?
Primarily.
Primarily at your place. And who would initiate those calls?
We would both.
Both do it. Okay. And on this occasion, she initiated the call.
Correct.
On those occasions, or let me ask you about this one. Was it going to be have sex and then leave, or was she going to stay the night? What typically would?
She would generally leave.
She would leave. Okay. So no further questions. Any questions based upon the court's questions?
No, Your Honor, thank you.
All right, thank you. So you may step down. Any additional witnesses for the defense?
There are not, Your Honor, thank you.
Your Honor, maybe.
May.
Okay, we're a few minutes in the Wayback Machine, so I'm gonna see if I can bump us past this. And the answer is no, we are now live and it is still privated. Oh,
I'll be in tonight, so I'll get taken care of.
Thank you.
Yep.
hold on.
Based upon the court's questions.
No, Your Honor, thank you.
All right, thank you. So you may step down.
Okay, yeah. I wanted to make sure I didn't accidentally push past something. All right, so it looks like Judge is off the bench. So while we wait to see if he comes back, let's go to another court. We'll circle back. Let's go to Lake County, Ohio. Vincent Collada.
Thank you, Your Honor. Your Honor, we're here this morning, case caption State of Ohio versus Stephen Pekarsky, case number 25 CR 000882. We were last here on January 27th, at which time the defendant entered a written and oral plea of guilty to count 3 kidnapping, a felony of the first degree, in violation of revised code section 2905.01B1 of the revised code, was a 3-year firearm specification is set forth in revised code section 2941.145, and count 5 felonious assault, a felony of the second degree in violation of revised code section 2903.1182, and a 3-year firearm specification as well on that pursuant to 2941.145. At that point in time, then the court referred it for a pre-sentence report and investigation, a victim impact statement, drug and alcohol evaluation, and psychological. Those have been completed, and we are here today for purposes of sentencing. Defendant is present with his counsel, Mr. Myron Watson.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Is there anything you would like to say at this time on behalf of your client?
Yes, I would.
Go ahead.
Yes, Your Honor. I would like for the record just to incorporate the sentencing memorandum and the letters of support about Mr. Pekarsky. We are not in any way, our comments are not designed to minimize what happened here.
Well, I'll incorporate the sentencing memorandum that was filed. You also had lodged an objection based, recognizing that what the law is in Ohio at this time, but still lodged an objection, understandably so, in case some reason the law changes on that in that aspect in regards to the firearm specifications in the Bowler case. And that will be, that objection I will recognize for the record is timely made and is being preserved for the record. I will state, at least from the court's position that the charges in this case are not allied offenses, and they would not and will not merge for purposes of sentencing, which I think distinguishes this from Bowler, but nonetheless, your objection is recognized and noted for the record.
Thank you very much, Your Honor. We believe here when the court looks at the statutory requirements and imposing a sentence that, promotes rehabilitation as well as the punishment aspect of it, we believe that a 9-year sentence would meet that requirement, Judge. And the reason why we take that position is that the lack of Mr. Pekarsky's criminal history, he does show remorse, and he will allocute on that fact. You can see from the letters that have been presented by family members and friends, they truly believe that this person generally has a good soul. I think what's also mitigating here, Judge, is you have Mr. Pekarsky who, for a difficult childhood and early drug use, and I mean, it was kind of shocking to know that his introduction into drugs was at a very tender age. He's tried to work and get over his addiction, but it's come with some hiccups and some missteps, which typically does happen for people who are chemically addicted to heroin and amphetamines. And I think what's mitigating here, Judge, is Mr. Pekarsky was in a long-term relationship with the complainant in this case, the victim in this case. There was a very emotionally charged issue about them having a child and his level of participation in that with regard to that child. I think that is factually not in dispute, that the argument and the disagreement and the later actions on his part, wrong, no doubt, but mitigated by the strong emotional situation that he really wanted to be involved with the child. And things spun out of control, and he was not thinking clearly because he was intoxicated, he was under the influence of drugs. That's not an excuse, and we're not using it as an excuse, but we're saying that based upon our contact with the complainant in this case, they feel like he's a good person. And that when our people interviewed the complainant in this case, they indicated that they wanted lenient treatment for him. That at some point when he's gotten his act together, to forge a relationship with his daughter. Mr. Pekarsky worked as a carpenter, worked very hard at it, was very good at it. But he had a bad misstep here, Judge, and it's nothing to minimize that. If there's any suggestion in my sentencing memorandum that I didn't believe that this was serious, that's not the case. And he's always acknowledged that he felt that it was serious. His overriding belief that he wanted to be a part of his child's life, and wanted to be a part of a family relationship with the complainant in this case. We're hopeful that the court would take in both the psychological report, which indicates that he was suffering from major depressive disorder, that he's had some mental issues going on that are currently being addressed. And we would hope that the court, with the proper programming and the proper working hard with the tools in which the prison will give him, will help him get over some of his problems and eventually be able to re-enter into society. We're optimistic about that. His mom is here, his sister is here. They're rooting for him. They love him and they care about them because they know what the struggle has been for him. And I know that the state probably said that it's not something that the court should give a great amount of weight to, but we will hope that the court will see its way clear that 9 years is a very long time for someone to be incarcerated, and that would not demean the seriousness of what happens here. And I believe that the complainant, and I think the court may remember that there had been a discussion as to the complainant, the person who has to raise the child on their own, the one who knows this man probably better than anyone else, felt that he should get some level of leniency despite the fact that the state will probably be asking for a sentence above the minimum. And I believe that Mr. Karski wanted to address the court as well.
Certainly, he has a right to address the court. And you do have that right, Mr. Pekarsky. You can say anything you want this court to consider before sentencing. Is there anything you'd like to say at this time?
Yes, Your Honor. I'd just like to say that I'm very sorry for what I've done, and I just hope that I can be forgiven and I can be in my child's life, and there's no excuse for what I've done. And I'm very sorry. I've had a lot of time to think about that. And I'm sorry.
Okay. Thank you, sir. Mr. Watson, is there anything else you would like this court to consider? Any other comments you want to make? You don't have to, I just want to make sure you said everything.
No, Your Honor. Thank you.
Ms. Linden, on behalf of the state of Ohio.
Thank you, Your Honor. Your Honor, as I indicated in chambers, the state is recommending a prison term of 15 years, 6 years for the firearm specifications, and then 9 years on the underlying. As I indicated in chambers, the credit is not 259, it should be 94 days. He did have a new offense that's not listed in the pre-sentence report for violating a protection order for his contact with the victim while he was in the jail. He was serving a sentence from September 2nd of 2025 until February 14th of 2025, so he would not get credit because he was serving a sentence during that period of time. Also, as I indicated in chambers, I want to place on the record that I take issue with what the sentencing memorandum says about the victim recanting. That is simply and absolutely 100% not true. She has been consistent from the day of, even in looking at her voluntary statement from June 11th of 2025 when this happened, and up until right before trial. Never once did she change her story. Yes, she felt bad for the defendant. She felt that maybe he had a mental break. She knew that these charges were serious, but never once did she waver. And quite frankly, I thought that maybe at some point in time she might, since she was talking to him on the phone. And when I asked her about it, she said no, she wasn't talking to him. Even though I knew that it was her, and I knew that they were speaking on one of his old phones. So I want to clear that up, because that's, in incorporating the sentencing memorandum, it should be noted that that's not true. When looking at the pre-sentence report, one of the things that I found very lacking was the defendant said that he was just glad that he didn't hurt anybody. And I guess he doesn't realize or can't grasp the extent of damage that he has done. The victim in this matter was so terrified that she ended up getting a protection order. And when you look at what happened that day, it started in the morning when she had been at his mother's house with him. She said she was going to look for an apartment. The defendant was mad about that and was not going to even let her leave the house that morning. When she finally did get a chance to leave, he followed her in his car, was swerving behind her, and she felt that they were going to get into an accident. Now, this is somebody who's saying that he wants to be in his child's life, but he knew full well at that point in time that she was pregnant. That he didn't seem to care about that. Shortly after, Nikki ended up pulling into American Electric, a parking lot there. And the defendant, you can see on the video, you can hear his tires are squealing, comes around, and he slams into the back of her car. She was on the phone with her mother when this happened, and her mother could hear that. He then takes off. She goes to the police department. She says, you know, I don't want to file charges on that, but I want you to know. And the defendant is told to leave her alone. So after that, she's getting ready to go home, and she's on the highway, and the defendant is behind her, and then in front of her trying to brake check her, and she's on the phone with her mom. She's in a panic. Mom says, hey, let's go to the Vrooman Road gas station. We'll go there and maybe we can talk. The defendant follows her there. I don't think the defendant realized that her mother was there at first. And she says, just, you know, leave this alone. Someone's going to get hurt. Now, I will say that Nikki did at one point in time, after they parted ways, say, you know, we're gonna have a child together, maybe he could come over for a cookout. Invited him to come over to her mother's house for a cookout. He didn't come. It gets to be 11 o'clock at night and the defendant shows up, pulls into the driveway. Victim sees that he is in the driveway. She comes out in her pajama pants, no shoes, no socks, no phone, basically in her pajamas. As she comes out to the truck, the defendant tells her to get into the truck, and she says, no, I'm not going to get in. He then pulls a gun and says, get into the truck. She doesn't want to get in, and so he grabs her by the back of her hair and he throws her in the truck. Again, she's pregnant, he knows this. They're driving around, and while they're driving around, he's yelling and screaming at her, saying, this will all be over soon, I'm going to kill you, I'm going to kill myself, and she's terrified. So this has gone on from morning until late at night. He even takes her at one point in time down a road, Wood Road, and that's actually where her sister had died as a result of a car accident. Drives her through that area, still saying that he's going to kill her. And whether you believe what he says to the police, that at some point in time they're arguing and he stops the car, shoots the gun off, and it goes through the roof of the car, or what she says is that he's so angry that he's slamming his hands on the steering wheel that he has the gun in his hand and it goes off. Not only that, but then he's slamming the gun on her leg to the point where she gets bruises. He tells her when they go to his house, they go back to his house. This is all the way from out near Madison Avenue, takes her all the way to Geneva, tells her don't do anything funny when she goes inside the house, gets her back into the car, and luckily he then takes her over to the gas station. When he goes over to the gas station, he has to go inside, and you can see on the video of her, as soon as he goes inside and that door is closed to that gas station, she hightails it out of that vehicle and she runs over, and luckily she's across from the Geneva Police Department. She is trying to open those doors, looking. And when I talked to her about it, I said, you know, why'd you keep looking back? She said the thing that scared her the most is that she was going to get shot in the back. She then goes around to the back of the police department. She's banging on the doors there, and luckily one of the officers lets her in. Normally, nobody would come in that way. All the doors have been locked. And then you see him on the videos driving past the police department, driving back and forth, looking for her, still even after that. Now, one of the officers from Geneva saw the truck, and so when she goes inside and describes the truck, one of the officers realizes he has just seen that. He goes and he ends up pulling the defendant over while he's pulling into where he lives. He ends up, he does have the gun in the car. I'm not sure at what point in time he unloaded the magazine of the firearm, but one of the reasons that we know the magazine was still in there for a period of time is not only did that one bullet go through the roof of the vehicle, but there was still one in the chamber. And although the magazine had been taken out and there were rounds all over the car, there was still one in the chamber, and unless he actually put that in himself, it fed from the magazine. The other thing that was interesting, and talking to the Geneva Police Department, they couldn't figure out why when they went up to the truck the first time, they could hear their voices and they could hear dispatch. The defendant had a second phone in his car, and he had this app called Broadcastify on his phone, listening to what the police were doing. So when you look at all those factors and how long this incident occurred, and then the defendant saying no one was hurt, he clearly doesn't understand that emotional and physical are both injuries. So when you look at the facts and circumstances of this case, having 15 years and asking for 9 on the underlying, I don't think that's out of the realm of what's appropriate at all. The minimum would completely demean the seriousness of this offense. This is one of those situations where when we talk about kidnapping, sometimes it's the technical violation. It's a kidnapping. This is why the statute was written. And we would ask then that you give the 6 years on the underlying offense, and then 9 years, or I'm sorry, on 6 years on the firearm specifications, and then 9 years on the underlying offenses, however the court deems that that would be appropriate. There is no merger. These are separate and distinct offenses.
Thank you.
Judge, can I respond just briefly as
Sure.
the recitation? I think, yes, this was an unfortunate circumstance, but I think the prosecutor left out is that the complainant in this case, along with mom, had invited my client to the home, so it wasn't like a situation he popped up
She said that.
unexpectedly. Huh?
She said that.
Oh, I missed that part. I missed that
Yeah,
part.
she said that they invited him and he didn't come.
Okay, yeah. So my apologies.
That's all right.
I didn't hear that part. Thank you.
This court has reviewed the pre-sentence report and investigation and psychological evaluation. I have considered the facts and circumstances of the offenses involved, the nature of the offenses involved. I received and reviewed the sentencing memorandum filed by Mr. Watson with the accompanying letters, and I've read all that, taken that into consideration. I have considered and read and considered the victim impact statement that was received by this court. I've also considered everything that's been said here in court by Mr. Watson on behalf of his client, the defendant himself, his comments, the prosecutor's comments, the recommendations from all parties. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. As for the factors in 29-29-12, factors indicating the conduct is more or less serious, the court notes that in this case, victim did suffer serious psychological harm, that the relationship with the victim facilitated the offense, and other relevant factors indicating the conduct is more serious is the fact that a firearm was used in this offense and actually was discharged, and also the fact that the victim was pregnant in this case. Those are all factors indicating the conduct is more serious, and he knew she was pregnant. Nothing makes it less serious. As for recidivism factors, court knows that the defendant does have a couple prior convictions. I'm not going to say a history of criminal convictions. I don't believe it's a history, but there was a theft conviction, misdemeanor theft conviction back in 2014. Drug paraphernalia charge around the same time, 6 months later. And that was it until this case occurred. There is a conviction also for violating a protection order that occurred after this happened and basically related to this, but there is a conviction for that, but was not prior. So he has 2 misdemeanor convictions that occurred about 10 years ago. In that one misdemeanor, there are probation violations that were filed, so he did fail in the past to comply with the previously imposed sanctions ordered by that court. Obviously failed to comply with the orders of a court with the TPO violation as well. Factors indicating recidivism is less likely. There's no delinquency adjudications, and the defendant did lead a law-abiding life for a significant number of years. Again, I mentioned the 2 misdemeanor convictions were 10 years ago. In this case, prison is mandatory due to the firearm specifications. Prison is consistent with the purposes and principles of sentencing, and the court notes for the record, defendant's not amenable to available community control sanctions. Therefore, it will be the sentence of this court that on count 3, the defendant serve an indefinite prison term of a minimum of 4 years, maximum of 6 years. On count 5, he serve a prison term of 4 years. The prison terms will run concurrent with each other. However, both counts carry 3-year mandatory firearm specifications, And those will be imposed for each count to be served prior to and consecutive to each other, and consecutive to the indefinite prison term of 4 to 6 years for an aggregate indefinite prison term of a minimum of, minimum of 10 years, maximum of 12 years. There's credit for 94 days that he served. The other time that he was in jail, he was serving a sentence for the protection order violation, the TPO violation that he was convicted of. So he's credit for 94 days. As far as the consecutive sentences go in terms of the firearm specification, those are statutory and required and mandatory, so there's no findings that need to be made for that. I need to advise you upon your release, you will be placed on post-release control for a minimum of 2 years, could be up to 5 years, that's up for the parole authority to determine. When on post-release control, if you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Balance of the indictment will be dismissed. Defendants ordered to pay all costs incurred in this action. Further need to advise you that you have been sentenced to a non-life felony indefinite prison term. And I need to advise you that there is a rebuttable presumption that you will be released from the service of that prison sentence after you have served the minimum sentence. So you first have to serve the firearm specifications, then you'll begin serving the indefinite prison term of 4 to 6 years. There's a presumption you'll be released after you've served the 4 years of that indefinite sentence, but that's not guaranteed. The Department of Rehabilitation and Correction, if they determine that while you're in prison that you have misbehaved, you haven't followed the rules of the institution, that you remain a threat to the community, you're not sufficiently rehabilitated, they can schedule a hearing for the purpose of keeping you in beyond the minimum sentence. You'll have a right to attend that hearing if that should happen. If they make that determination, they will then not release you. They'll schedule a new date for you to be released. There'll be a presumption that you'll be released at that new date. Again, unless you've misbehaved or a threat to the community, not rehabilitated, there's a presumption you'll be released. If they have a hearing again, because they don't believe, they believe that you have violated the rules, misbehaved, they can do the same thing. Under no circumstances, however, can you be kept in beyond the maximum sentence of the additional of the 6 years, beyond the first 6 years. I think that covers everything. Ms. Linden, is there anything else for the record that we need to address?
No, Your Honor.
Mr. Watson?
Only that we would like to make requests for a waiver of any costs. He's indigent. He's been incarcerated for some.
Court costs are going to be imposed. I'm not imposing any fines, but there's going to be court costs.
Thank you, Your Honor.
And just for the record, I don't have any, I know that was mentioned in the, I think, victim impact statement as well as maybe your memo. I don't have any control in designating where Mr. Pekarsky will serve his time, so that's up to the prison officials for that.
Yes.
All right, thank you.
Thank you.
Okay, friends, 10 to 12 with community control after that. That seems appropriate for what went down there, I think. We're going to go to Judge Simpson and get his verdict in just a moment, but before we do, Grandma TCF celebrates 10 months with 10 gifted memberships. So, Mom, thank you. So there's a thing when you do media, whether it be YouTube or whatever, and anybody who's done it will tell you, your closest friends and your family members, almost as a rule, could care less about what you're doing with media and with YouTube, with the exception of my mother. Been here every day, always takes an interest, asks how it's going. gets on my case when we're not getting more subscribers fast enough, asking me what's wrong, what am I doing wrong. So she's very engaged. And Mom, thank you for that. Hopefully what I'm doing here is making you proud. Okie dokie, let's go back to Judge Simpson and get that verdict.
All right, back on the case of people versus, is it Recep? Say it again. Reserve. All right. Closing argument.
To leave this in the discretion of the court.
I will escalate. Thank you.
Court was going to take a break and contemplate the decision. I don't think that I need to. In listening to the testimony in this case, and quite frankly, the defendant is in his home. There are 2 children there. Mr. Terrell's rendition of the facts and circumstances don't make much sense to this court as to why she didn't leave when requested to leave. The defendant had the absolute right to ask her to leave the home. She did not leave. Also, the location of her purse, she says it was someplace else other than where the defendant says that it was. And quite frankly, I think that the testimony and credibility of the defendant far outweigh that of Ms. Terrell in terms of the events as they occurred, the timeline of what occurred, and what he was then requesting that she then leave at some point because she is there, and I got the sense, way too long. I don't believe at all that the defendant in some way started throwing himself into a wall to cause damage, which just, I guess it could occur. I don't believe that that's what happened here. I think it was, as he stated, he lost his balance, came back, fell against the wall as there was this dispute going in. And quite frankly, given the entirety of the circumstances, it was incumbent upon Mr. Terrell to leave the premises. As indicated, it was his premises. The kids were there. She, at the point he asked her to leave, did not, and she did not, he did not, she did not have a right at that moment to then be there, regardless of what she may have thought about giving 30 and doing whatever. So for those reasons, the court would find, and I'm just be honest with you, I don't have a lot of credibility in anything that she's saying when I'm looking at her testifying and what she's telling the court. And so for those reasons, court would find that the people have not sustained their burden and would find the defendant not guilty of these offenses. Thank you. You're not on a tether, are you, sir? No, okay. Thank you.
I'm willing to bet that everybody in the chat agrees with that verdict. I'm still perplexed that the state even brought charges on this. It makes no sense to me. That was such a non-credible witness that the state threw their entire case on. It just baffles the mind. Programming note, I actually, for the 4th hour, I had some things I wanted to discuss, but I'm going to table it because there is a metric ton of good court happening out there today. A lot of stuff, and I would rather use that 4th hour to show you some good court. Because while the stuff that I was going to talk about, some court news and stuff is neat, I think this is better. So that's what we're going to do for hour 4 today. Let's head down to Florida. Wade Mercer in his first appearances. This was started about a half an hour or so ago.
Mr. Hickman, what I'm going to do is place you under oath and ask you a few questions. Mr. Hickman, do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
Thank you. So, Ms. Kaufman, let me tell you, first of all, you're here because you've been accused of one count of domestic battery. There is probable cause in the complaint, although I made a note that it's not an incredibly impressive case in the sense of evidence, but there's enough for probable cause. I've also made a note that you have no prior criminal history. Is that accurate, Ms. Kaufman?
Yes, sir.
Okay, so Mr. Hickman is here. You're the alleged victim, correct?
Yes, sir.
Mr. Hickman wanted to speak, and I wanted him to wait so Mr. McDaniel, of course, could hear everything also. So, Mr. Hickman, anything that you want to tell us or you think we need to know, Mr. McDaniel is her attorney for today's purposes.
Yes, sir. I just wanted to plead with you that she is a good person. She made a mistake, but she's good-hearted. She's a good mother. We depend on each other for work, so I really do want to keep contact with her.
Okay. Let me ask this question. You live together?
Yes, sir.
You have how many children together?
2 children.
And you want her to come back home?
Yes, sir.
Is that correct? You want her to come back home?
Yes, sir.
Right? And this is an isolated incident. Has anything like this ever happened before?
No, sir. This is the first time, and I will go to counseling, and we will work this.
Was there alcohol or drugs involved?
No, sir.
On neither side?
No, sir.
Okay. Mr. Mitchell, do you have any questions for Mr. Hickman?
I think that pretty much answered it.
Mr. McDaniel, any questions for Mr. Hickman?
No, Your Honor.
Okay. Thank you, Mr. Hickman, for coming. So, Ms. Kaufman, what I'm going to do is let you pick between a bond and a conditional release, ma'am. If you want to post a bond, the bond I set for this charge is $2,500 cash or surety. Some people prefer a conditional release. I'm going to offer you a conditional release because of your lack of any history. A conditional release almost always has a condition of no contact with the alleged victim. But given Mr. Hickman's appearance today and what he said, what I'm going to do is have a condition of no violent contact. And that condition would apply whether you post a bond or accept the conditional release. So your choice today to make is, do you want to post a bond and have fewer conditions to abide by, but have to post a bond to get out of jail? Or would you prefer to accept the conditional release and have more conditions to abide by, but typically it's cheaper than a bond? Or do you have questions about that option?
Judge, I think she was going to ask for the cash bond if that was available from the court.
Mr. Mitchell, any objection to a cash bond?
No objections.
$250 cash bond with a condition of no violent contact. That means you can have contact, you can live together. She has a condition, no violent contact. Hopefully it's an isolated incident and y'all work past this. I'm going to ask the jail to give you a notice. Ms. Kaufman, for your court date, that'd be March the 30th. March the 30th at 9 a.m. will be your court date, Ms. Kaufman. Ms. Kaufman, do you have any questions?
No, sir.
Mr. Hickman, do you have any questions? So as soon as the $250 cash is posted, she can be picked up at the jail. It's posted at the jail and she can have contact with you. Okay. Any questions? No questions?
Does it have to be cash?
Has to be cash. She chose a cash bond instead of a conditional release. So that's what her choice was a cash bond. So it has to be cash. Okay.
Judge, you want to explain to him the benefits of a cash bond very quick?
Yeah. So the way the cash bond works is if, let's say there's court costs and fines imposed under Florida law, the $250 has to go toward court costs and fines. But let's say the case is dismissed. Let's say Mr. Mitchell looks at it, he interviews you, and 3 weeks from now, he dismisses the case. If that happens, the $250 is returned to whoever posted it. That's why she's choosing the cash bond probably. She's hoping the case will be dismissed, and it may or may not. I don't know. Any questions? All right, Ms. Kaufman, are you going to be able to post the bond for her? Because if I was her, that's going to be her question. He says he's going to try to get that bond posted for you, okay?
Okay, yes, sir. Thank you.
All right. Wish y'all the best. We have Eve Strong here next.
Good morning, Your Honor.
Ms. Strong, good morning. Ms. Strong, your husband's in the courtroom, ma'am. Ms. Strong, you're here because you've been charged with one count of driving under the influence, ma'am. There is probable cause for this charge. You've also got a charge of refusal to submit to a breathalyzer or breath test. There is also probable cause for that. I'm going to appoint the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Ms. Strong. She's going to plead of no contest to the charges listed. Should be placed on probation for 11 months, 29 days, $1,078 in fines, 50 hours of community service, DUI class, minimum driver's license suspension. And she has waived the right to a jury trial and call witnesses, and this resolved this case today.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Strong, did you hear that agreement, ma'am?
Yes, sir, I did.
Do you have any questions about that agreement?
No, I do not.
Our clerk has a question. Yes, ma'am. It is a second-degree misdemeanor.
if she doesn't have any
'Cause
prior.
I'm not aware of any prior. And when I looked at the criminal history, there was some older stuff. Actually, I don't know if there's anything in her case. There was something in another, yeah, there was some older stuff, but I saw no prior refusal.
Yeah, so if it's no prior refusal, it's a second degree
It's
misdemeanor.
a second degree.
concurrent.
And your other question was what? Well, I have to judge her on the DUI, so I'll withhold on the probation on the other case. Okay. And I don't know what point I was at. Did I accept her plea?
Yeah, I think you just,
Sorry, did I? I can't.
No.
Did I accept the plea?
No.
All right. Ms. Strong, I'm going to accept your plea of no contest to these two charges, ma'am. I'm going to judge you guilty of the DUI because I have to under Florida law. I'm going to withhold adjudication of guilt on the refusal. I'm going to sentence you to the standard DUI first offender terms and conditions, which are 11 months and 29 days probation, standard court costs and fines, which I'll come back to in just a second, 50 hours of public service work. I do recommend the minimum driver's license suspension, but because of the refusal, you very well may have a year suspension because of the refusal, even if I recommend the minimum on the DUI. I'm also going to order the standard counseling. If you choose to do NA or AA, it's a cap of 12 classes. If you enroll in the DUI school within 60 days, that will satisfy your counseling requirement, and the court costs and fines were $1,078. The sentence on the refusal case is 6 months probation concurrent with no additional conditions, no additional court costs and fines. So, Ms. Strong, it's possible to get off probation early. In order to get off probation early, Ms. Strong, you have to do half the probation. So that means you got to do 6 months because the longest probation you're on, one you're on for 6 months, one you're on for a year, almost a year. At 6 months, you very well may get off everything if you get everything done. To try to get everything done earlier so you can get off early. Ms. Strong, what's going to happen next, ma'am, is they're going to bring you to the courthouse because that's where the probation office is at. They'll let you get dressed. They'll bring you to the courthouse. You'll meet with the probation officer, Mr. Goodson. Mr. Goodson will go over the probation with you. He will answer any questions you have, ma'am, and then you'll be free to go. Ms. Strong, let me see if your husband's going to be able to pick you up. Are you going to be able to pick her up, sir? She'll be downstairs probably in 30 to 45 minutes. The probation office is inside the county judge's office on the first floor. So, Ms. Strong, your husband says he's got transportation covered. He'll be here to pick you up. Ms. Strong, do you have any questions?
No, Your Honor, but thank you for
All
your
right.
time.
Yes, ma'am. Wish you the best. That's it for friends or family in the courtroom. Mr. McDaniel, so we can go back to the top of our docket, which is Alexander Gilman. Mr. Gilman, good morning. Mr. Gilman, you're here because you're also charged with one kind of driving under the influence. First offense. Mr. Gilman, I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel.
Your Honor, I spoke to Mr. Gilman. At this point in time, he's going to plead no contest to the charges listed. The understanding, he's placed in probation for 11 months, 29 days. He'll have to take a DUI class, $1,078 in fines, minimum driver's license suspension, 50 hours of community service. He has signed his plea waiver form, waived his right to a jury trial and call witnesses and that'll resolve this case today.
All right. Thank you, Mr. McDaniel. Mr. Mitchell's that agreeable with the state?
it is, Your Honor.
And Mr. Gilman, did you hear that agreement, sir?
Yes, sir.
Mr. Gilman, do you have any questions about that agreement? Any
Go ahead. Does it need to be, do the fines need to be paid in like one lump sum or?
Oh, no, no. You have the full
Okay.
11 months and 29 days to pay them, but
Okay.
if you want to get off early, you need to try to get them paid in 6 months. If you need more
Okay.
time, you've got the full time period, but try to get them paid at 6 months so you can get off early. Any other
Okay, yeah, that
questions?
sounds very doable. That is very doable, sir.
Any other questions?
No, sir, that'll be it.
Is this the plea you would like to enter, Mr. Gilman? Is this what you want to do?
Yes, sir.
I'm going to accept your plea of no contest to the charge of driving under the influence. I'm going to judge you guilty of that offense, sentence you to 11 months and 29 days probation with the standard conditions of probation. Mr. Gilman, in addition to the standard conditions, I'm going to impose the following statutorily required special conditions. Substance abuse counseling as directed by the probation office. 50 hours of public service work, successfully complete DUI school. I do recommend the minimum driver's license suspension. If you choose NA or AA, we're going to put a cap on it of 12 classes. If you enroll in the DUI program within 60 days, that will take care of your counseling requirements and you possibly may get off early at the halfway point. Mr. Gilman, just like Ms. Strong, you'll be brought to the courthouse to meet with the probation office and you'll be released from there. You will get to use the phone before you leave the jail, and you can be picked up at the courthouse in probably 30 to 45 minutes. Do you have any questions?
No, sir.
Wish you the best, Mr. Gilman.
Thank you, sir.
We have Ruby Clenny next. Ms. Clenny, good morning. Ms. Clenny, you're here for first appearance, ma'am, accused of 2 charges. You're accused of 1 count of battery on a person 65 years of age or older and 1 count of resisting an officer without violence. There is probable cause for these charges. Ms. Clenny, you have multiple prior arrests. However, they are, to what I can tell, they're all older, Ms. Clenny. Ms. Clenny, do you have somewhere to live other than the home where the alleged victim lives?
Yes, sir.
Where?
I am from South Carolina. Can I go home?
Asking where you gonna live at?
Hmm,
Where you gonna live at?
where I go?
You have
Where,
someplace to
where
go
in
to
South
get out?
Carolina?
I have all my family lives there.
So you have somewhere you can go in South Carolina?
Yes, sir. If I'd like
Do you
to
have-
go home.
Do you have somebody that can, do you have somebody that can pick you up from South Carolina or take you up there?
Yes, sir.
Okay, who would that be?
Next week.
Hard.
Next week, you got a court hearing.
Well, I can stay to, yeah,
You got a place to stay until
yeah,
next week.
until next week.
That's what he's asking you.
Pardon?
That's what he's asking you. Do you have a
Yes,
place?
yes.
Where?
I've got family here.
Law enforcement, the report says you had nowhere to go here. That's why this all happened, is they didn't, you have anywhere else to go. So my concern is, if I let you out of jail on a conditional release, I want to make sure you've got somewhere to be. What kind of court date does she have next week, Mr. McDaniel?
Well, I assume this court date for this case will be March 3rd, so.
No, that docket's off. That docket's passed. It'd be March 30th.
Yeah, because it's a felony. No, it's a felony, so it's, the day's cut off.
April,
This is a misdemeanor, right?
April 7th is for this docket. Is that right, Don? Oh, because it's felony court.
Yeah. It's bad on 65 or older.
Their cutoff is when? Well, the cutoff's today then, so it would make the next week's docket. He's right. Yeah, no, it's first appearance. Mr. McDaniel, you're right. The
Okay.
cutoff is today, so it's first appearance as of today. So ma'am, you would have court next week, but if it would help the situation, I have no problem giving you a court date for the.
April 7th.
No, listen to me, Don. If it will help her, I have no problem giving her a court date for the next arraignment date. When would that be?
April 7th.
I have no problem giving you a court date for April 7th, but again, my concern is you having somewhere to live between now and then, other than where the alleged victim lives.
Yes,
So
sir.
let
I
me
have
ask-
family. I have
Okay, let
family
me-
here.
Miss Clenny, who is here? Who lives here that you can stay with?
I have my niece lives here. I have several nieces that live here. I can find people, somebody
Okay.
here to live
So,
with.
Mr. McDaniel, anything else on behalf of Miss Clenny?
No, Your Honor, we just asked for conditional release.
Mr. Mitchell?
How much, you said it's older. How many priors does she have?
Oh, she's probably got at least a half dozen back in the 90s. Issuing worthless checks, a battery from resisting an officer without violence. Well, that's this one, excuse me. There's some in another state in 94. I think I may have saw a DUI in here, driving license suspended, stuff like that.
I don't, I mean, I assume they get the complaint, though. Jake, if you look at the complaint, you'll realize.
Yeah, given those factors, we have no objection to a conditional release if the court is willing to give that.
Okay, so Ms. Clenny, I'm gonna set your bond at $2,500 on each count, but now listen carefully. I'm gonna offer you a conditional release only if we can verify you have a place to live. That's the only way I'm gonna offer you a conditional release. We've got to talk to somebody that
Okay.
says you've got a place to live. So you're gonna get to use the phone after first appearance. You've got a
Okay.
bond set, you have the right to post a bond, you've got a condition of no contact with the alleged victim. You've got that right. But
Yes.
if you want the conditional release and not have to post a bond, you've got to verify you have a place to live. So Corporal, you can bring her up whenever you wish, once y'all spoken to someone that says she has a place to live, Corporal. If she can't put you on the phone with someone that has a place to live that says she can stay there, then it's a waste of time to bring her up, Corporal, because we're trying to take her back to the jail. I
Yes,
can't
sir.
give her a conditional release without a place to live.
Not a problem.
Corporal, if she has someone, if she has someone who has a place to live in South Carolina, but they've got to come pick her up. What we may have to do is bring her up here, get her instructed, and take her back to jail until they can show up to pick her up.
Okay.
Does that make sense?
Yes,
I
sir.
don't want her sitting at the courthouse for 7, 8, 10 hours waiting on somebody to get here from South Carolina.
Yes, sir. I understand.
So, Ms. Clenny, they're going to let you use the phone, ma'am. If you get a place to live, you can certainly get a conditional release. Otherwise, you can call friends or family and post a bond. But you can't go back there, ma'am, where the alleged victim lives. I can't let you do that right now. Ms. Clenny, we're
Okay.
going to give you a notice for your court date. Would you prefer the court date for next week, or would you prefer me to give you time to get things sorted out and have to be back in April?
April would be better.
Okay, what's the April court date again? April 7th at 8:30. That's an
Okay.
unusual date, Corporal, because we're skipping an arraignment date because of her situation. So April 7th at 8:30, and let Jeannie know why I'm doing this so she won't put on the docket for next week. And there is a no contact condition. Ms. Clenny, do you have any questions?
No, sir.
All right, ma'am. You'll get to use the phone shortly. Wish you the best.
Thank you.
Yes, ma'am. Eddie Seego.
How are you doing, sir?
I'm doing good, Mr. Seego. How are you, sir?
Well, I'm doing great, kind of confused. Just trying to figure it out.
All right, good. Mr. Seego, you're here because you've been accused of one count of grand theft of motor vehicle and one count of burglary of occupied conveyance. Mr. Seego, I wasn't sure about probable cause on that burglary. I emailed the attorneys this morning or texted them and said, I'm not sure that grand theft is burglary, but the Florida Supreme Court says I'm wrong. They decided about 20 years ago, apparently, that if you enter a vehicle without permission, that is a valid basis for a burglary charge also. So the officer knew more than I did in this particular case. Let me see if the attorneys have anything to add before I make a finding on probable cause. Mr. McDaniel, anything else? I know I just sent you that case 15 minutes ago. You may not have had a chance to read it.
I have not, but I assume that, this is an assumption, I don't know if it's correct, that, that he can probably be charged with both of them, but I suspect that he can't be convicted of one with the same incident. So I just asked the court, if that's true, to take that into consideration.
Yeah, I think that's true with dealing in stolen property. I don't think that's true with grand theft and burglary. It's true with grand theft and dealing in stolen property. Mr. Mitchell?
Nothing.
It's really interesting. The Supreme Court case says that when he entered the vehicle with the intent to commit it, that intent to steal, that was the burglary. The theft doesn't occur until he cranks it up and drives it off.
Until there's some.
So I would have thought the opposite. I would have thought the grand theft occurred first, but not according to that case law. So, Mr. Seego, you do have some very serious charges on your history. Now, I don't know the posture of these. I don't know where these stand. I think I saw a recent robbery. Is that case in Alabama still pending, sir?
No, sir, I deal with that since 2019, sir. But this case here, sir, I didn't even do it, sir. It's a false, it's like false.
All right,
Has
well, you
actually
got-
said that I did this, sir.
What did you say about the robbery charge? You said something 19.
I think EOS.
It was EOS, yes, sir, in 2023.
Well, the one I'm talking about, what I'm talking about says the date of November 22nd of 24. Is that the one you're talking about?
No, yeah, EOS, not seen it, sir. I'm not sure what you're talking about.
What did you say about 19? You talking 2019 you EOS or when?
No, I pled out to a robbery in 2019 in Alabama. I EOS that sentence in 2024. I went to prison and EOS the sentence ankle monitor when I come home.
It may be on here because they put you on an ankle monitor or something.
Yes,
Are you
sir,
still on
that's correct.
Are you still on supervision or are you through with that?
I EOS the sentence from the street, sir, on ankle monitor.
Are you still under supervision? Are you still on ankle
No,
monitor
sir.
or not?
No, sir, when it was sentence, sir, I'm not on supervision or nothing no more. I EOS it.
Okay.
So
Yeah, I know what
I was
EOS
free
means.
up to this point.
When did you get free of everything, Mr. Seego?
In 2024 when I EOS the sentence, sir.
Okay. All right. Mr. McDaniel, anything else on behalf of Mr. Seego?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Seego, based on your history, I'm going to set your bond at $7,500 on each count. It's cash or surety. That means you can go through a bondsman. You've got a condition of no contact with the alleged victim, Mr. Seego. And you'll get to use the phone in just a few minutes, sir, to try to post the bond. Mr. Seego, any questions?
Yes, sir, I got a question.
Okay.
Sir, upon what grounds am I being charged with this case? I'm literally sitting right here telling you I didn't do it.
I couldn't understand you. Could you say that again? Could you say that again slower? I couldn't understand you.
On what grounds have I been charged with this case? And I'm telling you I didn't do it. Is there any videos and any recordings, any witnesses, any other people, the victim? Can I get something to go off on?
There is a witness, and the witness says that someone in your clothing matching your description, she was sleeping in the backseat of the car. She woke up, you were driving the car away. There is also a video of someone stealing the car with your clothing description, and then they found you wearing the same clothing. So that's what's in the complaint.
Can we see this video, sir? Can we get in the recording, please, sir?
I couldn't understand you. Say that again.
He's wanting to see the
Yeah, you have the right to see. You have the right to see any evidence against you. You don't have the right to see it this morning. I haven't even seen it. But you have the right to see it eventually. But in the meantime, you've got the right to post the bond I've set for you. If you don't post the bond, let me finish. If you don't post the bond, the public defender's office will be in contact with you. Any other questions?
When's my trial date? Can I get the right to a speedy trial?
You may have the right to a speedy trial. You need to talk to an attorney before you do that. You haven't even been arraigned yet. So you cannot file a speedy trial notice until you're actually charged by the state. Your court date will be
this one. Wait, is it April the 7th?
No, felony court date is next week.
So based on this being arrested.
March 30th. Your court date is next Tuesday.
Without nothing.
March 3rd.
Just so
I
the public
apologize.
agree to what's been going on.
You got to stop talking at the same time I'm talking. We can't talk at the same time. So let me finish.
I'm in it right here, sir.
No, stop talking. It's my turn. His first appearance is completed. Send him, give him notice for March 3rd. Have a good day. Next case is Dennis Cole. Mr. Cole, good morning. Mr. Cole, the hold for Bay County came back as a violation of probation warrant. They have issued a VOP warrant based upon your new arrest here in Jackson County. You've got no bond on that VOP in Bay County. Mr. McDaniel, does he wish to do anything with the Jackson County case?
Yes, Your Honor.
Okay, listen to Mr. McDaniel, please.
Your Honor, we're going to plea of no contest to charges listed. The understanding he'll be sentenced to 60 days in the county jail. He'll have 9 days jail credit, be a $400 fine. He has signed a plea waiver, waived his right to jury trial and call witnesses with the right to withdraw this plea if they try to use the plea itself against him in the VOP.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Cole, did you hear that agreement?
Yes, sir.
Mr. Cole, do you have any questions about that agreement?
I do not, Your Honor.
Is that the plea that you would like to enter, sir?
Yeah.
Mr. Cole, I'm going to accept your plea of no contest into the charge of driving with no valid driver's license. I'm going to judge you guilty of that misdemeanor offense. I'm going to sentence you to 60 days in Jackson County Jail and give you credit for the time that you've already served towards that sentence, which was how much, Mr. McDaniel?
9.
9 days credit. I'm going to impose the standard court costs and fines set by state and county law of $400. Mr. Cole, when you get close to the completion of this sentence, you get it down to a week or 10 days or something like that, our jail will notify Bay County and say, he's almost through with his sentence. Do y'all want to go ahead and come get him? They'll come pick you up if they still want you. Then you go to Bay County, and when you get there, you'll go to a first appearance on the violation of probation I've just told you about. As part of this plea agreement, as part of the plea agreement, the plea itself cannot be used against you. That does not prevent the state from using the incident. They still can try to violate your probation based upon the arrest and the charge, but not the conviction. If they did that, I would let you withdraw this plea. Mr. Cole, so you've got 51 days left at most. You may do less than that under Florida's game time law. Mr. Cole, any questions?
No, Your Honor.
Wish you the best, sir.
Thanks, sir.
Yes, sir. Next case we have is Chad Kinsey. Mr. Kinsey, good morning. Mr. Kinsey, you are being brought up because the hold I placed on you, or one of us placed on you for Madison County, has came back as a no bond violation of probation hold. So you've got a no bond out of Madison County. In the local charges, resisting an officer without violence and trespass, please listen to Mr. McDaniel, see if we can get those resolved.
Your Honor, Mr. Kinsey's going to plead no contest in 2674 MM to the charges as listed. You understand he'll be sentenced to 6 months in the county jail. He'll have 10 days jail credit. There'd be a $370 fine. He has signed his plea waiver form, was waiving his right to a jury trial and call witnesses, and has agreed that this plea cannot be used against him in the violation of state probation case. Period. The plea itself.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Kinsey, did you hear that agreement?
Yes, sir.
And is that the plea that you would like to enter, sir?
Yes, sir.
Mr. Kinsey, I'm going to accept your plea of no contest to these two charges: resisting an officer without violence and trespass. A judge, you go to those offenses, sentence you to 6 months in the Jackson County Jail, but you've got credit for 10 days you've already served. Court costs and fines are imposed in the amount of $370. As part of this agreement, Mr. Kinsey, if the state wants to use this plea against you, I will let you withdraw this plea, but they still may be able to use the incident itself, the arrest or whatever allegedly happened prior to that, but you're not hurting yourself in the VOP by entering the plea. Mr. Kinsey, when you get close to the completion of this sentence, they'll notify Bay County to pick you up. If Bay County still wants you, they'll come and get you. You may actually do the last few days of your sentence in that county. But you finish this sentence here, you're through. There's no probation involved in the sentence here. It's just a straight jail time sentence. Any questions, sir? Any questions?
Yeah. No questions. All right, good luck to you, brother.
Thanks, sir.
Appreciate your best, sir. Keisha Dixon next.
She's been returned.
She's what?
She got returned herself.
Ms. Dixon's returned herself. She's already got a bond set.
Yeah, she's gonna try and post.
Craig Sorrell, Mr. Sorrell.
Yes, sir.
Good morning, sir. You were first appeared this weekend for the charges of driving under the influence and refusal to submit. Judge set you a bond. You brought back up this morning to speak with an attorney and see if we can get the case resolved. So listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Sorrell. He's going to plea of no contest to the charges as listed. The understanding, he'll be sentenced 11 months, 29 days probation, $1,078 in fines, 50 hours of community service, 10 days in the county jail. He has 3 days jail credit. He'll complete that as part of probation. He'll have to take the DUI class, maybe the advanced DUI class, I think possibly. Any kind of alcohol classes that are associated with it, community service hours 50, and whatever minimum driver's license suspension associated with it. And he has signed his plea waiver form waiving his right to a jury trial and call witnesses. And I didn't say he's got 3 days jail credit.
Thank you. Mr. Mitchell's agreeable with the state.
It is, Your Honor. I think he also needs to do 6 months probation concurrent on the refusal. This is a first time offense for refusal.
And Mr. Sorrell, could you hear all that, sir?
Yes, sir.
Any questions, Mr. Sorrell?
No, sir.
And is that the plea you would like to enter, sir?
Yes, sir.
Mr. Sorrell, I'm going to accept your plea of no contest of these two charges, driving under the influence and refusal to submit. I'm going to judge you guilty of the DUI. I'm going to withhold adjudication of guilt on the refusal. I'm going to sentence you to, on the DUI, let's do that one first, 11 months and 29 days probation, and with a the special condition, this is required by state law because you have 2 DUIs within a 5-year period. A special condition of 10 days in Jackson County Jail. You already have 3 days credit, $1,078 court costs and fines, successfully complete substance abuse counseling, 50 hours of public service work, DUI school. I do recommend the minimum driver's license suspension, whatever DHS&B determines that to be. The refusal will be 6 months probation and concurrent with no additional court costs and fines because you've already got a big court cost and fine on the DUI. Mr. Sorrell, try to get everything done early because it's possible to get off at the halfway point, sir. If you can get everything done, if you need the full 11 months and 29 days to get everything done, that's okay, on the probation at least. But if you can get it done early, then good for you. You may get off early. Mr. Sorrell, they're going to go ahead and bring you to the courthouse today. And the reason is when you do get released, I want you just to be released. I don't want you to have to report to probation then.
Yes,
so they're going to bring you to the courthouse, let you meet with Mr. Goods, and they'll go ahead and get you instructed on probation. Then they'll take you back to the jail to finish the 10 days. And when you get released, if it's 6 in the morning, you don't have to come and report in that day. You report in your next regular reporting period. So they will bring you and get you instructed this morning. Mr. Sorrell, do you have any questions?
No, sir.
All right, Mr. Sorrell. Wish you the best, sir.
Thank you, sir.
We have William McCrone. Are we seeing him today, Mr. McDaniel, or no?
No.
Okay. So we'll see Mr. McCrone on the next jail arraignment docket. And I think that may be it then. Mr. McDaniel, anything else from the public defender's office?
No, I mean, when it comes to Dixon, I'll bring her back up later. It's difficult. She can't keep her wits about her too well. So, I'll probably maybe bring her up Friday or something, see if I can't clear time served. But she's got issues.
That was the one at the hotel. It was a relatively minor trespassing, but with her history, she's not a probation candidate, I don't think.
No, she's not. I mean, she
And
can't
then on
volunteer.
Mr. McCrone, I sentenced him to that 5 months and 29 days. But I don't know if the issue with him was substance abuse, he was under the influence of something, or if it was mental health, but I've known him for years, and that's not typically how he behaves. So he wants inpatient drug treatment. He may be a candidate, but we gotta, I think he needs to be in jail a little while first if he decides to do that and y'all decide to do that.
We can just bring him back up at the jail arraignment.
Several times in the past. I mean, he's got more than likely a combination of both. He does have mental health issues, but I suspect it's a combination of both though, right now.
Well, if y'all brought him up on the 30-day, if he'd done a month and he wanted to go then, I would let him, as long as, I give actually on the contempt, I don't know if the state has any input, but we've got to try to resolve the new case also. So I'd get input from the state and we'll see where we go from there. But gentlemen, so we may have some pretrial motions tomorrow, may or may not, after first appearance, Mr. McDaniel.
Yeah, I got to finish him up. Jake may not object to them, so, I'll send them over.
And then we've got a bench trial Wednesday, a bench trial Thursday. Don't forget that we have Calhoun County first appearances the rest of this week. I'll try to remind y'all when I send the notes out tomorrow.
All right.
Anything else, Mr. McDaniel?
Those Calhoun County ones, are we gonna, or can you call in like this, like here, or do I need to, do it on my phone or just out of curiosity? I guess I always do it on my phone, but I didn't know if you wanted to call in like you do
We do
right
the
here.
rural county link?
You just do the Calhoun County link.
Well, that's all procedural. We don't need to listen to them talk about that. But yeah, bench trials Wednesday and Thursday. He'll probably stream them. So as long as he does it during our hours here, perhaps we can watch those. I mean, we watched the one trial that he had with a jury, and that was a pretty interesting watch. So I think it's worth looking at. Okie dokie. I would like to direct your attention to the pinned chat real quick. Tonight in the blind with Mike and Dan, or with Mike and somebody. We'll see what happens tonight. But we're going to go forward one way or the other, I think. So please do check that out. There is a link to the show for tonight up there. So if you're not familiar with In the Blind, go over there. It's a lot of fun. It's not court stuff. But the unique part of that show is we have no idea going in what we're going to talk about. It is presented to us in real time, and it's a whole lot of fun. So check that out. Okie dokie, let's go to Texas. Judge Stevens.
Let's see if Manhattan comes into the German hill country. This is the fancy New York hotel. I mean, interestingly, those two cultures will evolve. And I need a phone. It would be, understand this. Yeah, that's what they were. We got them rolling here. 25 CR 1457 is called the State of Texas versus Stanley Curtis Etheridge. That's you, sir. And you were here with Mr. Dutzler. You were attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary? Yes. In summary, Mr. Etheridge, this indictment alleges that on or about September 19th, 2025, in Jefferson County, Texas, you committed the third-degree felony of what's called continuous violence against the family. It states you intentionally, knowingly, and recklessly caused bodily injury to another person with whom you had a dating relationship and assaulted that person. Do you understand what you're charged with here, sir?
Yes, sir.
It's a third-degree felony if convicted, which means you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
Agreement has been reached. He would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $1,000, and there would be other terms and conditions of probation, which are normal and customary for this type of offense. Do you understand what is happening here?
Your Honor, the only,
We got an issue here on the signing of this agreed punishment recommendation.
Yeah,
Redo that.
He wrote on my line, Judge, so I kind of made a line there.
Okay, we gotta start over.
tell us it's jail, aren't they, three?
Be careful on listening. So that is the most interesting stylus that's ever been manufactured. It takes more than just coordination. It's almost like you have to perform a magical act.
See, that's what lets me in, the coordination part.
You gotta hit two things at the same time that are in different spots for it to erase, which is, I don't know, you would think.
And Judge,
It'd be a better way to make a.
the agreement is for 10 years, and placed, and then be placed on supervision. He's gonna ask for less than 10 years.
Hey, before I sign this, can I ask a question? Can I ask a question?
What did you say?
Can he ask a question?
Oh, yeah. Then try math. I'm real good at that.
Okay, it's $1,000, but the 10-year probation, is that $1,000?
I don't even know what you're talking about.
The fine can be
$1,000
over the term of probation, not all of the time.
Okay.
Yeah, you do a little bit at a time, like you're paying a car note, but it's no interest. There's no interest charged. But at the end, you don't get a new car.
Okay. But do I have a chance to get a house?
Yeah, but you're gonna get out.
It's lost out.
You don't have to pay your fine when you get out.
Okay.
It's gonna be over the term of probation, a little bit at a time. And if you do well on probation, your probation can be shortened to 1/3 to just 3 years, a little over 3 years. And that's what I do every day is shorten probation. 93% of the people are successful on probation on our watch. If I follow this agreement, sir, you have no right of appeal. Do you understand that?
Yes, sir.
How do you plead to this, guilty or not guilty? How do you plead guilty or not? Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
And because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it?
Yes.
Discuss it with your attorney. Or the contents all true and correct here?
Yes.
State's Exhibit 1 is tendered into evidence and without objection, it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is hereby again.
Yes, sir.
Do you still have any relationship here with the victim in this case?
Yes.
You do?
Yes.
Uh-huh. What are we doing about that?
Needs to be a no contact, Judge.
We are separated. We live in 2 different residences. And we say, the relationship was a 9-year relationship, and it still brings us stuff like that. The situation was that it wasn't a violent thing, it was a violent act.
That's not what you just pleaded guilty to.
But I pleaded
this. Don't say you pleaded guilty just to get it done.
Yeah.
You either pleaded guilty, you were under oath, you either committed a crime of lying, perjury, Because you said all of this was true and correct. All right, this states you pulled her hair, threw her to the ground, intentionally and knowingly caused bodily injury.
Yes.
You call that a love relationship?
Whatever.
That doesn't act like it. No.
But you know, y'all still don't live together.
We don't live together.
Well, don't say that you didn't do anything wrong here because, and if you treat somebody you care for, you had a relationship, an intimate relationship with, what would you do to somebody you didn't care for when you got upset? I mean, that's just, you got to control your temper, I guess. But this isn't the way that you show love toward another person, right? Okay, we'll fix that. All right, if nothing further, I'm going to find you are mentally competent to enter this guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. I find you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer.
Yes, sir.
And based upon State's Exhibit 1 and your representations to the court, your entry of plea of guilty, it's voluntarily knowingly and made upon discussions with your attorney, I hereby find you guilty beyond a reasonable doubt of this third-degree felony of continuance violence against the family. And I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 10 years. That term of confinement is suspended. You were placed on regular probation for 10 years. You must pay a fine of $1,000. Was there any restitution here? No, this lady?
No, sir.
There will be terms and conditions of probation, which are normal and customary for this type of offense. You must complete the Batterers Intervention Protection Program. That helps you maintain your composure when there are times of stress. And you will have no contact with this victim unless otherwise ordered by the court. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked and you could be sentenced up to 10 years in prison. So make the most of this second opportunity, okay?
Yes, sir.
Anything else? No. Thank you. That is all.
Good morning once again, everybody. It is TCF Live. Happy Monday to all of you. I hope you're all enjoying your morning so far. I know I am. Let's go back to Judge Collada in Lake County, Ohio. I think he's going to do a sentencing, but there's people gathered for this one. Normally we don't see an audience, but there's an audience here.
We're here today in 3 separate cases, all entitled State of Ohio versus Curtis L. Wilder. Those case numbers being 25 CR 001550, 25 CR 001551, and 25 CR 001737. Defendant is present in open court today with his counsel, Corey Hinton. We are here today for sentencing on all 3 cases. The defendant was last before Your Honor on January 13th of 2026, where he pled guilty by way of information in each of the 3 cases. In 1550, he pled guilty to 1 count of grand theft of a motor vehicle, a felony of the 4th degree, and 1 count of grand theft, a felony of the 4th degree. In 1551, he pled guilty to 2 separate counts of grand theft of a motor vehicle, felonies of the 4th degree, and 1 count of breaking and entering, a felony of the 5th degree. And in 1737, he pled guilty to 2 separate counts of grand theft, felonies of the 4th degree, and 1 count of theft, felony of the 5th degree. At that time, the pre-sentence report and victim impact statements were ordered. It's the state's understanding that the pre-sentence report has been completed and provided to the court, and that multiple victim impact statements were also submitted. And it's the state's understanding that all parties are prepared to go to sentencing at this time, and that's the state's understanding at this time.
Thank you.
Mr. Hinn, is there any reason not to go forward with sentencing? I did receive your sentencing memorandum and have read that. Any reason not to go forward with sentencing?
No such reason, Your Honor.
Is there anything you'd like to say at this time on behalf of your client?
Yes, Your Honor. There are quite a few things I'd like to highlight. As you know, based on the sentencing memorandum and the letters that I attached, Mr. Wilder, he's a father, a son, a friend of many. Certainly has a lot of good characteristics that these folks are seeing in him. He served our country as a Marine. Unfortunately, the drugs got the best of him. Him and I have had a lot of conversation about that. I know that these offenses here were directly related to drug use. I do know that despite that, it's my understanding that Mr. Wilder was cooperative when he was apprehended, that he gave information regarding other cases of his, that he helped locate some of the vehicles. I know that he was last in treatment in Euclid, and it is demonstrated in the pre-sentence report. I had asked him about that, and that appears to have been more of a detox facility as opposed to anything long-term treatment. He does indicate that he made arrangements and does have a bed available at the Salvation Army. It's a 6-month program there. I talked to him about maybe looking at the VA or other resources as well. He indicates that he's not on probation or parole to any other court. I spoke to Mr. Wilder about restitution, and that there is restitution being ordered or being requested and likely ordered. On this case, did indicate to me that he is employed as a CDL. I did ask him about his license because I noticed in the pre-sentence report that there wasn't a valid license, but he seems to be able to get that back, and it may have expired. So he does have work available to help him with the restitution. But I think getting to the bottom of the drug issue is certainly important here. I understand that there is a lengthy history, that there has been 12 prior prison commitments. So that's not something I'm blind to, or that my client's blind to, but I know he has a good heart. He certainly wants to get better for himself and his family, especially his son. With all that said, Your Honor, we would ask that you consider community control. Again, I know with prior prison sentences and other things, what would normally be a presumption for community control with felonies of the 4th and 5th degree can be rebutted. But we would ask you to consider that. If the court did not think that community control was appropriate and instead was going to order a prison sentence, I would ask the court to consider something less than 5 years, and I think that would open the door for the possibility of requesting judicial release at a reasonable time, so that, again, this idea of treatment can be explored. I know that there's an individual here, Frank DeMario, that wanted to speak as far as the veteran component goes. I did speak with Mr. DeMario to see what he would be speaking about. I have no issue with him speaking. Neither does my client. So with that said, Your Honor, I'd like to call Mr. DeMario as a witness if the court would so allow.
Sure, sir. You can just stand right where it is that you're seated, state your full name for the record, and state whatever you'd like me to know.
Yes, Your Honor. My name is Frank DeMario, DeMario. I'm a retired federal agent, retired supervisor at Lake County Narcotics, and I've been working with incarcerated vets for the past 3.5 years. I've been working with the defendant for the last few months, and we've been talking about the importance of him setting a good example for his 14-year-old special needs son. And he understands that. And he understands that the importance of his son in his life. And And his son was taken by his mother for 4 months. He did not know where his son was. It was finally found by the Cleveland police. That's the time that he began using again and committed these crimes. I believe that with rehab, he would be able to overcome the use of crack, which he's addicted to. I would ask that he be considered for treatment, Your Honor, in order to get his life straightened. Thank you very much.
Thank you. Mr. Henn, anything else?
Your Honor, I know my client would
sure.
like to speak, but nothing further from myself. I just would like to reiterate what I said, what I indicated in chambers, and what I indicated in writing prior to the hearing.
Thank you, Mr. Wilder. You have all three of these cases, and in all three of these cases, you have the right to address the court before your sentence and say anything you want me to know. Is there anything you want to say at this time?
Yes, sir. I do apologize to people that I harmed, taking their stuff. My son got kidnapped, kind of lost faith after a while, lost hope, couldn't find him, didn't know what else to do, turned to drugs, and that's how I currently in this situation. I had a pretty lengthy criminal history. Been out of prison for 7 years. It's the longest time I've ever been out of prison. I had a couple relapses in the process, but nothing that led me to crime until after Nasir was kidnapped and I lost hope. I ended up losing my job at Ford. From there, I started using a little more heavy, and then I was trying to hide myself and still support my drug cabinet, pay my bills, and it didn't work out like that. And I was arrested by the Willoughby Police Department for the Wycliffe Police Department. I took them to 2 vehicles that they told me about. They showed me and asked me what I know about. And I just asked for an opportunity to probably try to help some treatment to get my life in order at that point. I was really tired and lost. This officer here told me about his family, and I told him about how I ended up in this situation. We spoke at length that day about it. Tried to contact him, but I didn't know what to do. The officer behind me was the arresting officer, but I didn't know who was what. I've tried to do as much as I could to right my wrong, and I do apologize for any harm I caused anybody. Given the opportunity, I will do better. I'm just trying. Sometimes I just don't know what to do. I ask for help. I try to get as far along as over the hump to be a better person. Just asking for a chance. I don't care what the length is. If it's however long treatment may be, 2 years, a year, whatever it may be, I just want to try to get my life together. Thank you, sir.
Thank you. Mr. Hinton, anything else?
Nothing further, Your Honor.
Special State of Ohio.
Thank you, Your Honor. These cases go back to August of 2025 all the way through the end of October of 2025. Law enforcement made the decision, so they were investigating both Wycliffe Police Department, Eastlake Police Department, Willoughby Police Department, and Mentor Police Department were all investigating various thefts of vehicles, trailers, and equipment. When they determined who the individual was, they were still investigating, but because of the continual nature, including incidents occurring in other counties such as Summit County, they made the decision to arrest him as soon as possible because there seemed to be no stopping the number of places that were broken into, the items that were taken. So the reason this stopped only had to do with law enforcement working very hard to locate, determine, and connect this defendant to each of these locations. through his cell phone, through flock camera, through videos at different businesses, whether it be the business that was actually the victim or businesses that were around. They used a lot of different aspects to determine who was breaking into these different places, taking our items, things of that nature. So it was an investigation that 4 different departments were involved in, with Wickliffe and Willoughby being 2 departments that, between getting the warrant through Wickliffe Police Department's cases and then Willoughby making the actual arrest, they all worked hand in hand to bring these cases to the court. So the victims did suffer economic harm as well as psychological harm. All of them had economic harm, which I will go through, but the smaller businesses also struggled to continue their business and their work. There were some bigger companies that were able to replace things quickly and easily and get back to work, and then there were smaller companies where one individual indicated to me that Mr. Biddick, that he found out his insurance did not cover his tools. So he was unable to get insurance for those things. So he had to start replacing tools as quickly as he could to continue with jobs. He couldn't really do all of them at the same time because it was a large expense. Mr. Walker also had that issue with being able to get back to work to replace the tools. Because even when insurance did help, they still had to be replaced, even if the money wasn't as large of the issue as it was trickling down. So we have in 1550, Nicholas Spancara, he had his pickup truck taken. Insurance did cover some aspects, but he is out $1,743.82. Then we also have Bernard Giannetti Landscaping. He had equipment from 3 different trailers. The trailers were broken into and the equipment was taken. He did have some insurance. He was able to recover some, but out of pocket was $3,188.09. He also indicated his concerns with having his equipment taken again, something happening, that he did install a fence around the property in hopes that this would not happen to he and his company again. That fence cost him $16,900. In 1551, we have Gregory Ambrose. Insurance did cover some, but I believe his victim impact statement indicates he is still out $8,572.85. Mr. Tyler Hart had to pay his $1,000 deductible. Mitchell Archibald is the breaking and entering charge. His door was damaged. He did not get me the receipts, but he did suffer economic harm. This was the second time in a week that his business was broken into, Arch Landscaping. That did affect him as well. In 1737, we have Abram Biddick, who his insurance was not covering what he needed to replace. I believe he sent a victim impact statement in for $6,925. Mr. William Snow had some insurance. I believe his victim impact statement ended up being approximately $4,138.99. And Mr. Joey Walker indicated his deductible was $500. I did speak with all of them personally, and they were all obviously very upset at the effect it would have on their business and moving forward, and just how it affected them in general. The people would go onto their property and either take their trailers or their trucks or break into either buildings or trailers to take large-scale equipment out that is not easily replaceable, and obviously it built up over time to have successful businesses. This is part of organized criminal activity. Besides the defendant admitting that he was stealing with others, the video evidence also shows at multiple locations, multiple people, whether you saw people together or they came in multiple vehicles, so clearly there had to be more than one individual there. Show that he was working with other people to take these items away from these victims. Before the cases in Lake County occurred, there were also in the beginning of August cases or reports taken for Stowe Police Department, Bath Police Department, and Twinsburg Police Department. At least one of those has charges out of Summit County, the Twinsburg case. So he was doing this ahead of time, and it's the state's understanding that he was on bond at the time he was committing offenses. He does have a history of juvenile adjudications and criminal convictions. It is a very extensive list that the pre-sentence report lays out, with it beginning in 1993, where he did do his first prison sentence in 1993. For probation, he has 29 felony convictions and 13 misdemeanors. Throughout the years, he has convictions for property crimes in 1993, 1994, 1995, 1997, 1999, 2000, 2001, 2002. In addition to 2002 to property crimes, he also has domestic violence, as well as trafficking in cocaine, preparation for sale, and possession. In 2003, he has property crimes. In 2004, he has drug and assault charges. He also had I failed to mention in 1994, there were probation violations. In 2004, is a probation violation. Those convictions continue in 2005 with property crimes. 2006, he has property crimes as well as an attempted robbery. 2007, more theft convictions. 2008, he has a failure to comply as well as drug charge with probation violations on the failure on at least one of the charges. He had probation violations in his 2008 failure to comply when he was given judicial release. So he initially went to prison, was given judicial release, and had multiple probation violations. The same in the 2007, one of the theft cases. In 2010, he has more property crimes. He had probation violations in 2 out of the 3, and eventually went to prison after violations. 2011, receiving stolen property. 2012, he has breaking and entering convictions, as well as attempted engaging in a pattern of corrupt activity, grand theft of motor vehicle, possession of heroin, and receiving stolen property. It's the state's understanding restitution has not been completed in those cases. He also in 2012 has a federal conviction for theft from interstate shipment, trafficking in certain vehicle parts, altering VIN, operating a chop shop, and conspiracy to operate a chop shop. He was released from that prison term in October of 2019, and he was placed on supervised release, which ended in April 10th of 2024. He had multiple violations while he was on supervised release, with new cases as well as testing positive. I believe it was for both cocaine and heroin. And in 2021, he has additional convictions. One of them is for theft, felony to the 5th degree, where he was put into veterans court. He had 8 probation violations in that case, and then he had another grand theft where probation was unsuccessfully terminated. And then in 2025, he has received stolen property as a misdemeanor. He has multiple pending cases and or warrants out. There are 2 Cuyahoga County felony cases, Maple Heights Police Department and Brooklyn Heights Police Department, for felony property crimes that warrants were issued in November of 2025 for failing to appear. And then the Twinsburg Police Department Summit County case I referenced, he is pending grand theft, felony 4s, 2 counts, with a warrant issued in December of 2025. So based on probation's count, there are approximately 12 prison terms, one of them being a federal prison term, and this is on 23 different cases where he was sent to prison. There was one issue in jail that the state is aware of involving an assault. His conduct has been very similar through thefts, breaking and entering, and receiving stolen properties. He did indicate an issue with drugs. We are not denying that. He has had many opportunities for treatment that are outlined in the pre-sentence report going back to 1994 for defendant, all the way until 2025. And it appears if I have the dates and understanding correct, that when he was in Glen Bay from June of 2025 to September of 2025, that he was engaged in multiple of these offenses. 2 of them in Lake County occurred on August 5th of 2025, and then there were some on August 2nd, 2025 in other jurisdictions. Based on all of that, the state does feel that he's not amenable to community control and that prison is consistent. His last Ohio prison term was 5.5 years. I am unclear on what his federal prison term was, looking at my notes. But we do feel that prison would be appropriate in all of these cases, and it should be substantial, especially based on just getting off a supervised release in 2024 in April, and then between a year and a year and a half later, he's engaging in all of these activities. So prison has not seemed to change his attitude on engaging in these activities, and punishment is appropriate in this case. So we would ask for on the high end of prison, but over the most recent prison term being 5.5 out of Ohio, we feel it should be greater than that number. He has credit in each of the cases, depending on how the court wishes to sentence him. He would have 114 days credit in 1550, 111 days in 1551, and 42 days in 1737. The 1551 and 1737 dates are included in 114 in the 50-50 case. And we would ask for the restitution that I previously outlined, as well as we do think consecutive sentences are necessary to punish and protect. They wouldn't be disproportionate. He was on bond, as well as he has a history of criminal convictions that show that consecutive sentences are needed. And that would be the state's recommendation at this time.
Thank you. This court did review the pre-sentence report and investigation that was completed in this matter. I received multiple victim impact statements. I've read and considered all of those. I received a sentencing memorandum from Mr. Hinton. I've considered that. I've considered everything that's been said here in court today by the defendant, Mr. Hinton, Mr. Mario, the prosecutor, all the recommendations. I've also considered the particular facts and circumstances of each of the offenses involved here and the nature of the offenses. All of this is considered by this court in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, in all 3 cases, the court finds the defendant acted as a part of organized criminal activity, and that in each of these cases, the victims suffered significant economic harm, and several of them, many of them, suffered serious emotional harm as well. Small-time business owners are truly impacted on this, and that's not fair to them. That's not right to them. And there's no reason that they have to deal with this. Many of these people took not just the monetary impact it had on them, but it took hours and hours of their time as well to deal with different companies and trying to get back on track. And again, they did nothing to bring this upon themselves, and they did nothing to deserve any of this. No factors indicate that defenses are any less serious than normal. As for recidivism factors, I mean, I've been doing this a long time, and I don't remember seeing a record like this. Been sent to prison 23 times. For 23 separate cases, you've been sent to prison, resulting in 12 separate prison numbers, meaning several of the cases were running concurrent to each other, and you got a break in that regard, and weren't punished separately for those cases. You have 29 prior felony convictions. That's not counting, 12 or 13 misdemeanor convictions, if I'm remembering correctly. Convictions in federal court. Juvenile delinquency adjudication, we have the UIS. I mean, your criminal history goes back 40 years. 40 years. Just nonstop criminal activity, very similar to what we're here for. Aside from the time periods that you were locked up, this is what you do. Theft, 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 grand theft, grand theft, theft, receiving stolen property. Just take what doesn't belong to you. And other people have to suffer because of it. And you don't think you should be punished for this. There are multiple times where you've been given help. You've been put on probation. And there's multiple probation violations. Heck, the last time you were in Veterans Court, you violated at least 7 times. And they just kept continuing you. And that's why you're back here, because nothing happens to you. But there's multiple times where you have failed to comply with previously imposed sanctions from this court. From not this court, from courts. You say you want to be put on probation and you can get a job because you have a chance to work and you'll make restitution. You owe thousands and thousands and thousands of dollars still to other people for the crimes that you've committed before.
That was piped out.
You've been ordered to pay restitution before, and that hasn't been paid. And I expect that you're going to pay the restitution in this case? Defendant contends there's a drug abuse problem that relates to the commission of the offenses. I don't know if that's accurate or not, but you put yourself into a program here this summer, and while you were in the program, you were committing crimes. No factors indicate recidivism is less likely. I mean, recidivism is guaranteed here because that's what the history shows for 40 years. But that's what you do. Prison in all 3 of these cases is consistent with the purposes and principles of sentencing. There's just no way this court can make any finding defendants amenable to available community control sanctions. Therefore, in case 25 CR 1550, it'll be the sentence of this court that in counts 1 and count 2, defendants serve a term in prison of 12 months on each count. Those terms shall be served consecutive to each other. Defendant has credit for 114 days he served. Court will further order the defendant in this case, at least I'll order the restitution. I don't expect it to get paid, but to Nicholas Svankara in the amount of $1,743.82, and to Bernard Gianetti in the amount of $3,188.09. In case 25 CR 1551, it will be the sentence to this court that on counts 1 and 2, grand theft of a motor vehicle. Then each of those 2 counts, the defendant be ordered to serve a term in prison of 12 months on each count to be served consecutive to each other. On count 3, the defendant is ordered to serve, this is the breaking and entering charge, a term of 9 months in prison. That'll be concurrent to counts 1 and 2, but the prison term will be served consecutive to the prison term imposed in 25 CR 1550. Since it is consecutive, there's no further additional credit in this particular case, as that credit's been given to the defendant in 1550. In this case, the court orders restitution to Tyler Hart in the amount of $1,000, which is the deductible that he had to pay for his insurance company. The rest of the money was paid by the insurance company, and I guess I'm not allowed to order that, so that's free money for you. The court will also order restitution to the Ambrose Company in the amount of $8,572.85. Lastly, in case 25 CR 1737, it will be the sentence of this court that in counts 1 and 2, defendants serve a term in prison of 12 months on each count. On count 3, the charge of theft, defendants serve a term in prison of 6 months. Those will each be ordered to serve consecutive to each other and consecutive to the prison terms imposed in 1550 and 1551. There's no credit in this case, again, as that credit's already been given to the defendant in 1550. This is an overall prison term of 6.5 years in prison, with 114 days of credit. In this case, the court's going to order restitution to Joey Walker in the amount of $500 for his deductible, to Afrin Biddick in the amount of $6,925, and to Rad Air in care of Bill Snow in the amount of $4,138.99. Let the record reflect, none of these orders of restitution involve reimbursing the victim for the fence that was installed. I don't have the authority to do that. Just for the record, I know I'm well past it, but under recidivism factors, the court also finds the defendant was on bond when these occurred and had outstanding warrants for his arrest in several other cases when all these offenses occurred. I need to advise you, upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of these conditions, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by this court. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court further orders the defendant pay his court costs for each of these 3 cases. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. The court further finds that consecutive service is necessary with all 3 of these cases to protect the public from future crime and to punish the offender if they are not disproportionate to the seriousness of his conduct and the danger he poses to the public, and that he committed 1 or more of these offenses while on bond awaiting trial. In other cases, that at least 2 of these offenses were committed as a part of 1 or more courses of conduct, and the harm caused was so great or unusual that no single prison term for any of the offenses committed adequately reflects the seriousness of his conduct. And most importantly, the offender's history of criminal conduct demonstrates consecutive sentences are necessary to protect the public from future crime by the offender. Quite frankly, these are all separate offenses that you committed affecting separate victims, all who have been impacted by your criminal conduct, and they deserve to be punished separately. I'm not going to let you commit 1 crime and then just go ahead and commit a whole bunch and just run them all together and benefit from committing multiple crimes. These are separate offenses where you, again, seriously impacted the lives of many individuals, and they deserve to have separate consequences and separate punishments. I think that covers everything. Is there anything I omitted or need to address, Ms. Cutts?
No, thank you, Your Honor.
Mr. Hinton.
Your Honor, there's just two things that I'd like to be heard on. The first, Mr. Wilder, he did indicate to me, and this is just for clarification, but he thought that some of the restitution in the previous cases may have been addressed in an appellate case. I told him I would look into that, but he did want me to clarify that point with you so that you understand why he hadn't made restitution in those cases. On the second point is, Mr. Wilder does have family here. He was hopeful to have some sort of brief interaction with them, specifically his son, at the conclusion of the proceedings.
No, I never allow that. It's up to the sheriff's department, and I'm not going to, no reason to provide any exceptions for Mr. Wilder.
And there you go, my friends. Somebody in the chat said add all of that up. Yeah, that's too complicated a math. To be honest with you, there's no way these people are ever going to collect, sadly. I mean, you know it. They're just out the money. And that's too bad. All right, our commitment to 9 to 11% more Judge Boyd. Let's go to Texas. Oh, as soon as I hit the right button. There we go. Okay.
Morning. Good morning, Your Honor. All right, the court is calling 2024 CR 011234, State versus Angela White Magpie. Could I have parties announced?
Ready for the state. Ray Lopez for the defense.
And are you Miss White Magpie? Yes, ma'am. Am I pronouncing your last name correctly?
Very correctly.
Thank you. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Miss, did you review the application for deferred adjudication with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah.
Ms. White Magpie, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Oh, all right, let me explain it differently. Sometimes my question is confusing. All right, do you understand the rights you have? All right, do you want to enter into this plea?
Yes.
All right, and you know by entering this plea, you're giving up those rights?
Yes.
And are you intending to do that?
No.
Not
Wait.
willing to give up your rights.
Yes, yes.
Okay,
Yes.
that's
I'm
okay.
So sorry.
No need to apologize. Sometimes we get nervous and sometimes my questions are confusing. So you understand you have a right to
Yes.
remain silent.
I understand that.
When you enter this plea, you're giving up that right. You understand?
Yes, sir.
You have a right for the state to call whatever witnesses they think they need to prove their case. You understand?
Yes.
And when they call their witnesses, you can question them or either your attorney can question them. You understand?
Yes, sir.
Because you're entering this plea, you're giving up those rights. Did you understand?
Yes.
And did you intend to do that?
Yes.
You also have a right to a jury trial. And so 12 jurors will sit, they'll listen to whatever evidence is presented and decide on whether you're guilty or not guilty if they can come to a decision. Do you understand?
Yes.
Because you're entering this plea, there's not going to be a jury trial, so you're giving up that right. Do you understand?
Yes.
Okay. Did you understand if I grant your application for deferred adjudication, if for any reason your deferred adjudication is revoked, I could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
All right. Court will find that defendant has knowingly, I'm sorry. Just 1 second. I'm making it something in the paperwork. Just 1 second. Okay. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Miss, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No,
Are you satisfied with the way you've been represented?
yes.
All right, if you're not a US citizen, when you enter this plea, you will be deported, denied naturalization, or reentry. Did you understand?
Yes.
All right, court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes.
Defense?
It is, Your Honor.
State?
Yes, I understand, Judge.
Did you review the waiver of appeal paragraph with your attorney?
Yes, Your
Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 100 hours of community service restitution, the DOEP course, and anti-theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Honor. No contest.
State, any evidence?
Judge, up to number 1 and all counts. No objections, Your Honor.
All right, state, you may be excused. All right, did you review the waiver and stipulations with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments. Just one moment. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on your client's behalf?
We just asked the court to follow the agreement.
All right. So do you have any family here in?
Family.
Okay, because it shows that you're originally from a different state.
Originally, yeah, but I have family that lives here and I live here.
All right, so who do you have for a support system?
My wife of 12 years, my son, and most importantly, my grandkids. I just recently had, I haven't been in any trouble and trying to be a positive role model for them.
All right, so what is it? So this is from 2023.
Yes, Your Honor.
So have you been in any type of rehab or anything of that nature?
I'm Native American and I've been in close contact with my culture, Native American culture, which is very inspiring. I've been sober for 2 years, 3 months and some weeks. I've been doing really good. My grandkids changed my life.
Okay, and how old are they?
6, and I had one Christmas Eve of this past year.
All right, so who lives in the home with you?
My son, his wife, my grandchildren, and my wife.
All right. All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication, $1,000 fine, that will be probated. When's the last time you had employment?
That's what I'm looking forward to now. I have a job with 5 Guys, hamburger,
Yes.
burger place.
All right, now I heard of them.
Yeah, I'm excited to get back to work and get started.
All right, proof of employment within 45 days, no employment as a home health care provider or with minors. regular reporting by Zoom or in person, regular random UAs, 100 hours of community service restitution. I'm going to order parenting classes. Once she completes that, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. TAP evaluation out of custody. Follow recommendations. However, if it recommends inpatient treatment, we'll start with outpatient treatment. And there's going to be 20 sober support meetings in 20 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am, I'm looking forward to being successful in this behind me.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, so we can go off the record. Here's the thing. Do not disappear on probation. If for any reason you feel as though you're going to use, pick up the phone, call probation and let them know. And you know what they're going to do? They're going to contact me and they're going to give me a sheet of paper. And on that sheet of paper, they're going to say, you need some additional help. And guess what we're going to do? We're going to give you the additional help. So don't say, you know, I didn't report because this is what's going to happen or this is what's going to happen. Nobody has a crystal ball, right? Stay in touch with them. Okay.
I will.
All right. Good luck to you.
Disappointed.
All right. Thank you so much. Good luck.
Thank you. Good luck to you.
Okay, thank you.
Who's next?
Page 330.
Granny, thank you for the $2. I will PayPal that over to Michael. I think I might owe him some money for some other stuff today too. I gotta look. In the Blind with Mike and Dan tonight does look like it's going to be Mike and Dan. Link up in the pinned chat, 7 p.m. Eastern, 4 Pacific. So unless Michael gets really, really bad, not good news, we should see him on that show tonight.
For competency evaluation. So we had that last week, but then they realized the insanity. So they are trying to expedite that. This is a case where the complainant, the deceased is the defendant's mother, and he thought she was the devil.
Okay.
So
Well,
I'm not sure.
They actually have it set, according to my system, they have it set in May.
That doesn't surprise me.
Your Honor, and I think some of the holdup may be the discovery that Dr. Whoever is completing the insanity evaluation will have to review all of the discovery, and it is very.
Yeah, they sent him, I think, 10 or 15 reports, but I think they'll probably have to look at all the body cam video as well.
Correct, it's body cam, jail calls.
Norma?
Norma stepped up, Judge.
You stepped out, Judge.
All right, we're gonna set this for, let me see. All right, so we will set it on May 26th, because I think Memorial Day is on the 25th. All right, so I will come back on May 26th.
Thank you, Judge.
Thank you, Judge. Appreciate it.
You're welcome. They have a setting, so it'll be status.
Okay.
Okie dokie, let's stay in Texas, but let's go say good morning to Judge West.
Are you Precious Eaglin?
Yes, no.
And are you sick today, Miss Eaglin?
Yes.
Okay. Miss Eaglin was previously in court in cause number 25 DCCR 0317, entered plea of guilty to assault on a peace officer. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections?
Just a clarification, Judge. I think when Ms. Egan reported her version of events to the probation department, she more or less is, denying guilt in what appears to be actually referencing the aggravated assault. It's been her contention all along that she did not commit the offense of aggravated assault.
Right.
And thankfully, Mr. Nichols was willing to let us plead to one or the other. And so she is not a convicted felon. And we are asking the court to accept this because of the fact that she does not deny the plea of guilty that she entered for the assault on a peace officer.
So that's very important, Ms. Eaglin. And what Mr. Eckhart is saying, you only pled guilty to the assault on a peace officer, not the other case. But what you said was you weren't guilty in here, which gives me some concern. Is what he's saying correct, that you're taking responsibility for the assault on a peace officer, but not the other?
Yes.
Okay. Anything, Mr. Nichols?
No, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. We find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 7 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation at the end, the case will be dismissed. You'll never have a felony condition of probation. You can be brought back into court, found guilty of the offense, and sentenced to prison anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you. Thank you. And I'll sign that dismissal and cause number 25 DCCR 0318. Do you have that, Kim? Do you have anything up there? No. Okay, thank you. Thank you, sir. Say, Judge Walker on David Viano.
How are you?
How about you? Again, all right, so you're David Biano. This is 25 DCCR 1212. Mr. Biano is charged with aggravated assault with a deadly weapon. And what is the announcement?
We are going to get some documents to the prosecutor and get it specified.
Okay. Any issues?
None that I'm aware of.
All right, so we'll just do a normal reset about 30 days or so. Make sure you stay in touch with Judge Walker. He'll let you know when you need to be back in court, okay? All right, thank you. Mr. Rojas, you have Terrence Currington. No, she sent it. You sent it? Yes. Terrence Currington.
I don't have any paper.
Oh, okay. All right, sir, are you Terrence Currington? This is clause number 25 DCCR 1114, and what is the announcement?
Judge, we received the video last week. Mr. Carrington wants to come in and look at it if I can get a reset.
Okay, any issues?
No.
So, Mr. Currington, I'm going to reset your case one more time. Make sure you call and make an appointment. Go visit with Mr. Rojas. Y'all go over the video, any other evidence that he's received, and we'll get an announcement at the next court date. Okay, see you at the next court date. You're free to go. Marquise Berry. Good morning. See Mr. Nichols? Did we lose Mr. Nichols? On Marquise Berry. Your bonds.
Back there, Judge.
Okay. Are you, thank you, Mr. Smith. And, you're Marquise Berry. And this is 25 DCCR 0882. Ms. Berry's charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, Ms. Berry made an appointment with my office, and I think where there was a mix-up, we could keep it with her. I'm just asking for recess so we can make another appointment with it.
Okay, any issue that you know of? Ms. Berry, I'm going to reset your case one more time. Make sure you call and make an appointment. Go visit with Mr. Rojas before that next court date, okay? All right, thank you. You're free to go.
Thank you, Judge.
Mr. Barrington, you've got Alexander Thornton. Good morning. Mr. Smith, this is Alexander Thornton. Good morning, sir. Are you Alexander?
Yes, ma'am.
And Mr. Thornton is charged with fraudulent use or possession of credit or debit cards. This is 24 DCCR 0323. And what is the announcement?
Your Honor, we actually have some progress in this case, is that we were trying to get him on a veterans docket, if the court will recall, is that he did not qualify, is that talked with Mr. Smith this morning. We have a tentative agreement on the plea. He's got a case in Jasper that's new and unindicted. I need about a week to try to work that out. We can plead next week. That's possible.
Okay, any issues? All right, I'll reset. How does next show do 1 or 2 weeks? Does it matter? I mean, you can come in next week and play it. Let's do
If I can get Jasper done, yes, ma'am. 2
I'm
weeks
gonna
or better.
reset it for 2 weeks for a plea, and so make sure if.
I'll take care of Jasper.
And if it's not, it's gonna be time to move this one anyway.
Yeah.
Okay. Stay in touch with Mr. Barrington. I will see you back in 2 weeks for a plea.
Thank you, Your Honor.
Thank you. Mr. Burbank, you've got a sentencing with Diamond Smith.
Good morning. I'm standing in for Sam, Rachel.
Okay. Morning, are you Diamond Smith? And Ms. Smith was previously in court in cause number 24 DCCR 2056, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child. I've received that pre-sentence report. Has everyone had an opportunity to review it?
We have. Ms. French has indicated to me that she has, Judge.
Are there any additions or corrections?
No, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity because you don't have a felony conviction. And if you successfully complete the probation, at the end, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and then you could go to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. Yes. All right. Good luck to you, ma'am. Thank you.
Thanks.
All right, let's pivot back over to Judge Boyd, new contestant.
All right, court is calling 2025 CR 012573, State versus Joe Victor Compa.
All right, we're gonna be on the record.
Can I have parties announced?
Anthony Cantrell for Mr. Compa.
And are you Mr. Compa?
Yes, I am, Your Honor.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did, Your Honor.
Are you the same Joe Victor Compa who was placed on deferred adjudication in 2025 CR 012573 for the offense of possession of a controlled substance penalty group 1, 4 grams to 200 grams on December 2nd, 2025 for a term of 6 years? Is that you?
Yes, I am.
All right, state.
Violation of condition number 1 on or about the 17th day of December 2025 in Fair County, Texas. The defendant, Joe Victor Compa, committed the offense of possession of controlled substance penalty group 1 and violation of condition number 1.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1?
Sorry.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, it is to deny the state's motion amend the conditions to include status followed by status aftercare. And the state will be taken into consideration clause number 2025 PF 50304.
That is our agreement. No.
All right, so Mr. Compa,
Yes.
I can follow the state's agreement. What that'll mean is that you'll remain in custody until transfer to SATA. Probation, what is the wait time for SATA?
Currently, it's 2 to 4 weeks.
All right, that's 2 to 4 weeks. Or I can revoke you, and if I revoke you, I'll sentence you to 4 years in the prison. Which do you prefer?
The first one.
Okay, all right.
By all means, Mrs. Bond.
All right, thank you. State you may be excused. Oh. Go to the state. All right, then this is what the court will do. The court will deny the motion. Alter and amend conditions to include the following. He's to remain in custody until transfer to SATA. Probation, is he eligible? Did we already do a referral to felony drug court for him? All right, so what I'll ask for is he's to remain in custody until transferred to SATA, followed by aftercare or acceptance into the felony drug court. And there's to be no unsupervised contact with minors. And once you presented the court with some negative UAs, that may change. But for now, no unsupervised contact, okay? All right, is there anything else you need from the court? All right, we can go off the record. Here's the thing. If you think you're going to use or you feel that you're going to use, let probation know. And you know what's going to end up happening? They're going to try to get you the help that you need. But if you're just out here and not doing anything, that's going to be a problem, okay?
Yes, Your Honor. I don't want that.
All right. And I'm sorry, Cindy, back on the record, the court is taken in consideration as a part of the agreement 2025 PF 50204. Is that the correct number?
It is, Your Honor.
All right, thank you.
Thank you, Judge.
All right, good luck to you.
Thank you.
All right, we'll stay in Texas, but let's have Ellie sit down so I can see what I'm doing. Thank you, sweetheart. Let's go back to Judge Stevens.
Yeah, 2 and 3 are. Yes. Yes. Different punish.
The punish is a third.
Degree felony.
It's a third degree. 2-state jail permits.
No, but there's those 2 state are.
2-state jails makes it third degree possession.
Name one, right there. Okay.
Even in sequence?
Yes. Yes.
You are Brandon Edward Hoffbauer. And here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, Mr. Hoffbauer, this indictment, stand by. Pains, God bless him. This indictment alleges that on or about September 25th, 2025 in Jefferson County, Texas, you committed the state jail felony of terroristic threat against a peace officer. Do you understand what you're charged with here?
Yes, sir.
Now, paragraphs 2 and 3 go on to allege that you have prior convictions of state jail felonies, one in 2014 out of the 252nd District Court of Jefferson County next door for illegal possession of a controlled substance.
Yes, sir.
And paragraph 3 goes on to allege that you were convicted in 2021 in the 128th District Court of Orange County, Texas for illegal possession of a controlled substance. Paragraphs 1, 2, and 3 constitute a state jail felony, but it is punished because of the prior convictions as though it were a third-degree felony. Do you understand how that works, sir?
Yes, sir.
Which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty to paragraphs 1, 2, and 3, sentenced to 3 years in prison. And you will, of course, be given credit for all time you have served in accordance with this matter. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of a state jail felony terroristic threat against a peace officer? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3 that and looks just like a 3. It looks like 1, 2, 3, 3. Let me fix this in. If show you what's marked as State's Exhibit 1. Did you sign that document?
Yeah.
Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
All right. And how do you plead to this paragraph 1, state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3, those prior convictions we discussed of state jail felonies, are those true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those voluntarily and because they are true as they are alleged?
Yes, sir.
This constitutes a state jail felony, but it is punished as though it were a third-degree felony. And that's how you get the more than 2 years confinement, 3 years as agreed upon. In State's Exhibit 1, among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read the indictment. It is you were guilty of the crimes charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All
Yes, yes.
Nothing further. I will follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted, find you guilty beyond a reasonable term of 3 years. Do you understand?
Yes.
What has happened today, sir?
Yes, sir.
I think it'll be confined in the institutional division of the Texas Department of Criminal Justice, actually, not the state jail, because of the enhancement. You will be given credit for all time you've served. Anything else to add, sir? Okay, good luck. Thank you. That is all. Yeah, it was balanced. Yeah. This one, Patel. Mr. Patel. Here we go. That's yours, Ryan.
Yes, sir. Yes, I'm here. Yes.
You're not Sager.
He is.
There he is. Come on.
Let's leave Judge Stevens behind. Let's go back to Judge Boyd for the final hearing of the day.
Announcements.
Brandon Brady for the state.
Stephen Harkowitz for Jeremiah Johnson.
And are you Mr. Johnson?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jeremiah James Johnson who was placed on community supervision in 2021 CR 9283 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on June 1st, 2022 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Judge, we're seeing a violation of condition number 2, specifically that on or about the 20th day of June 2024 in Uvalde, Texas, County, Texas, the defendant, Jeremiah James Johnson, is then and there illegally used a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
Not true. That's true.
All right, so to that violation of number 2, you plead not true? All right.
I'm sorry, Judge, is that true or not true?
He said he's pleading true. State?
Judge will also be proceeding on a violation of condition number 4, specifically that in Berry County, Texas, the defendant, Jeremiah James Johnson, is then and there failed to report to the supervision officer as directed for the month of July, August, September, and October. Of 2024, violation.
True to violations 2 and 4?
Yes, ma'am.
Court will find 2 and 4 true. Is there a proposed agreement?
The agreement is to revoke the defendant. It's looking like he got out of TBC around.
Well, I mean, you got agreement to revoke. And what are y'all asking for?
Judge, we're asking for the full 3 years.
And is that the agreement?
Judge, and well, Mr. Johnson is asking for some credit.
No. So first, I like to go through steps. So the first thing, are you all in agreement that he is revoked?
Yes.
Are y'all in agreement that he be sentenced to the 3 years?
Yes.
All right, so the court is going to revoke. The court, and are you waiving your right to appeal?
Yes, ma'am.
All right, so the court is going to revoke. The court is going to sentence him to 3 years in the prison. Give you credit for any time served. So it appears that what you all were trying to tell the court is how much time you have. The person who needs to know the exact time you have or you're saying you have, the clerks, because the clerk needs to put it in the system. What I can tell you is I'll give you credit for any time that you've served on this case. So anytime a warrant has been active on this case, you get credit for that. Anytime you've been waiting in jail to have this heard, you'll get credit for that.
Okay, so
If you had some other case that you went to TDC on and this was still pending, you'll receive credit for that.
okay.
Okay?
Yeah, yes, and that's where we're getting at. It's my understanding from checking with the clerk last week, he's got 135 days in Bear County.
Okay.
Now, he had cases in Uvalde? Medina County, excuse me. And that he went to a rehab from 1/27/23 to 7/20/23. That was 175 days. And what Mr. Johnson is telling me that when he went to the rehab for the cases in Medina County, he was supposed to be given credit for, was it an outpatient or
Yes.
here on the cases
Oh,
that he
well, I
had
can
here?
tell you is I cannot legally give you credit for any outpatient treatment. Now, if you successfully completed inpatient, then you can receive credit for that. But for outpatient treatment,
No.
the court legally cannot give you credit for that.
It was a 6 months inpatient program at CCF in Uvalde County.
Okay.
And you got, for my outpatient program I was supposed to do here, so you guys used my inpatient program. So that's why I was trying to get that credit time for that too.
All right. Anything else?
Yeah, and then in addition, he went to TDC for on 11/15/2024, and he made parole on 1/1/20, 1/23/26, and they had to detain her
The whole time.
at TDC. So he's asking the court to give him credit for that.
All right. He'll receive credit for the 135 days in the Bear County Jail. He'll receive credit from January 27, 2023 to July 20, 2023 for successful inpatient treatment. He'll receive credit from 11/15/24 to 1/23/26. Is there anything else?
Yeah, oh, and then he's also asking, Your Honor, to run this case concurrent with the two cases he's on parole. I have the case numbers for that. That's 22-03-14359 CR. Then he has a second case, 20-02-13565 CR.
Wait a minute. -135.
13565 CR.
All right. This run concur with 22-03-14359 CR and 20-02-13565. I'm sorry, 13565 CR.
Correct.
And there's to be no residing with minors. And no unsupervised contact with minors. All right, good community. It doesn't increase the time that you're in custody, but it can help you maintain your sobriety. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yeah.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
All right, make better choices, all right? Who's next?
All right, friends, plural. That brings it to a close for today. I hope you all enjoyed yourselves. I know I did. Except it looked frozen. Yeah. Okay. I think now you see me. Everything froze, and now it's like not froze. I don't know. So this is definitely the right time to end the show before things completely collapse. All right. I hope you all enjoyed yourselves. We'll be back tonight for In the Blind with Mike and Dan. That is at 7 p.m. Eastern, 4 Pacific. There's a link for that up in the pinned chat. That is a separate channel. That is not law content, but it is a good time, so join us. I'll be back tomorrow on this channel, 9 a.m. Eastern, 6 Pacific, half an hour earlier if you're a channel member. So go have yourselves a great day. Hope to see you tonight and tomorrow. Take care. God bless.